rule issue koro. It appears that the civil revisional application arises out of an order for out of a prayer for transfer of a matrimonial suit from mat suit number 142 of 2019 which is pending before the learned additional district judge fast track second court at Barashat. A coordinate bench, my predecessor, by an order dated February 9, 2022, having found possibilities of settlement, had directed that the element of settlement be explored through mediation. Accordingly, Mr. Anirban Pramanik, learned advocate, a trained mediator, was appointed to explore the possibility of settlement through a meaningful process. The learned mediator has filed a report, filed the final report of mediation. It appears that the petitioner appeared in person, petitioner wife appeared in person along with learned advocate. The opposite party husband also appeared in person along with learned advocate. The mediation was held on several dates and terms of settlement had been arrived at. According to the terms of settlement, the learned mediator, the opposite party husband agreed to, both parties agreed to approach the learned district judge at Barashat to take steps and pray for decree of dissolution of marriage. The opposite party husband agreed to withdraw Miss Case number 123 of 2020, pending before the learned district judge at Barashat. Stop. The father of the opposite party agreed to withdraw WPA number 8815 of 2020, pending before the High Court, and title suit number 119 of 2021. The wife agreed to compound the criminal case being GR case number 207 of 2020. Compound case number 58 of 2020 corresponding to GR case number 207 of 2020, and also to and also case number 186 of 2021 corresponding to GR case number 393 of 2021. Priya SARKAR further took steps, agreed to take steps to withdraw CR number 18 of 2020, CRAN number 2 of 2021, the husband undertook to return the gold jewelry, etc., and other household items as mentioned in the terms of settlement, as also pay a sum of rupees 30 lakhs in 3 equal monthly installments. No, but thing is, matrimonial suit was directed as also title suit number, matrimonial suit number 142 of 2019 and title suit number 19 of 2021 were agreed to be withdrawn immediately after receiving the final installment. But I can only dispose of. I cannot now enforce this.
Yes.
What can I do?
Just Lordship, just the direction that both parties will comply the order of the mediation only. Yes. Because they are not appearing several times. I approached them. Already I have paid 30 lakhs.
Give me your receipt. Receipts have been filed by the husband indicating that entire 30 lakhs have been paid. But the have you withdrawn? You are supposed to do what?
Lordship, I will withdraw all the cases which are filed. But Lordship, in case number matrimonial suit 142 2019, the district court they say directed that we will comply as soon as getting the order from the high courts. So Lordship, if Lordship directs that.
It appears that several notices were issued to the learned advocate for the wife, but none appears despite such notice. Give the notice. It is further submitted that the notice was sent by WhatsApp as the learned advocate for the wife. What is her name?
So, Priya SARKAR.
Wife and name now, Okil and name.
Mr. Ashok Hallar.
Huh?
Mr. Ashok Hallar.
How did you get the name?
I have also reached him through the call as well. The
name is nowhere in the documents before the court.
Lordship, Mr. Amit Ranjan Pati and Ashok Hallar, both are the advocates.
Now there is Shunayan Ghosh. Ashok Hallar. It is submitted that Mr. Ashok Hallar, learned advocate, is not available in the High Court, and as such, the notices were sent via WhatsApp. The terms of settlement have to be incorporated in the order of this court. The husband has complied with his part of the order, with his obligation to pay the money. The wife has received all the money, and it would be unfair to linger the matter only because the wife chooses not to appear after having taken the money from the husband, after having accepted the money from the husband. Thus, this court is of the view that rule be issued upon the opposite party, upon the petitioner, Srimati Priya SARKAR bracket Kundu, returnable on 1st August at 10:30. In the meantime, the husband is directed to comply. You want to withdraw or you want to wait for the next date?
Lordship, we want to withdraw if
The
possible.
husband and the husband's father, in the meantime, the opposite party and his father are at liberty to comply with their obligation as per the terms of settlement by withdrawing the pending litigations.
Grateful, Lordship.
Mr. Ghosh, I was looking for you because I wanted the written statement of that matter, which was, please give it. Matter which was heard.
My lord, my lord, there's some mistake, my lord, record to be corrected. It has been civil court, Kagdeep, it would be Diamond Harbor. Lord, this is my lord, the awesome mistake on my part in the prayer portion and the cause title. My lord, though it is stated in paragraph 4, I have stated
So
clear.
you're not supposed to go through every paragraph.
That's
Mr.
my lord, I beg to
Mantri.
apology.
You are
I beg
supposed to
to
be a little more careful. Second code act,
Diamond Harbor.
1,
place
2,
of Kagdeep.
3, 4. In the fourth line of the first paragraph of the order dated so and so, Kagdeep be corrected as Diamond Harbor. That's all?
Yes, madam. No, the only thing is liberty be given to correct the cause title, my lord. Otherwise, my
It
lord,
is granted to correct the cause title of the revisional application as also the prayer portion. Please correct in the cause title and prayer
here
and
and
then serve them. Yes.
same is my lord, that is wrongly printed year 2013. It would be my lord, 2023 has been done. It would be 2013. That the second paragraph, a second line. First page and second line. It would be 2013.
First paragraph,
First line, second line, 2023, suit number 274 of 2023.
the title suit number 274 of 2023
Yes.
as appearing in the first and second line of the first page of the order dated so and so be corrected as title suit number 274 of 2013.
Yes. Another mistake, my lord, the second page in line, my lord, the 2, 3, 4, 5 line. It is a miscase number, year 2019 in place of 2016.
সবই তো এখানে আছে দেখো ফার্স্ট প্যারাগ্রাফ একদম উপরে একটু খুলে দেখতে হয় খালি পাওয়া যাচ্ছে না
It is 2019.
In the third line of the first paragraph of page 2 of the order, miscase 14 of 2016 be corrected as miscase 14 of 2019. বারবার করার সময় একটু চেক করে নিলেই তো হয় ওরা ভুল করলে একরকম যদি ঠিক থাকে তাহলে এই ভুলটা কেন হয়?
এটা আমি কারেকশন করে দিয়ে দিচ্ছি।
Yeah, Lordship. Lordship, it is a withdrawal
Petitioner
petition.
does not want to proceed with the matter. Written instruction is there. Where is your written instruction?
No, this is the thing that it has been wrongly filed here in the section. It is a DV Act cases. So
the
we want to
petitioner
withdraw
wants
it.
to withdraw the divisional application as the same is not maintainable before this court with liberty to file is approach the appropriate forum.
Indeed grateful.
Prayer allowed. Dismissed as not withdrawn.
My lord, this is the affidavit of service. File the extension application, my lord.
Take it out.
Extension of interim order.
Service has been made effectively.
Why are there two cans, 2 and 3? Both are for extension.
That has been disposed of. This is the last can, number 3.
That is for extension.
Can 2 তাহলে appear করছে কেন dispose of হয়ে গেছে তো তাহলে only can 3 is pending.
Yes.
Service effectively upon parties and the learned advocate to the lower court.
এই যে,
কোথায় গেল?
No one didn't turn up.
What is the order impugned? Have you served?
Yes,
yes,
my lord.
affidavit of service is there, my lord.
How many opposite parties?
One opposite party, my lord. One opposite party, my lord.
Never
The
appeared.
service has been effected upon the learned advocate in the lower court and also to the parties. There,
Never.
but no one didn't turn up.
Till date. ওই ঘরে
Give me a copy of the can. Can 3 of 2023 is an application for extension of the interim order dated December 22, 2022, passed by a coordinate bench. The original application cannot be traced due to change of courts. The records have been misplaced. It is submitted by my court staff. No, it is submitted that the application was filed for being listed in a particular court, but after change of determination, the application has not been tagged with the file which is before this court. Hence, a copy of the application is taken up and treated to be a true copy. Office is directed to trace out the main file. The original original application. Yes, what is the case?
My lord, the case is that there is a suit for eviction, my lord. I am the defendant. I am entered appearance by filing the written statement along with the application for vacating the ex parte stage. But the written statement are kept in the record. My application for vacating the ex parte stage, that application was unmoved due to the laches of the landed council in the court below. But subsequently, I filed the application for recalling of that order, but that application is still pending. That is the situation. And the next
Which order?
well, the order is that order number 18 dated
What
3rd.
about 7172?
My lord, that application was not taken out, my lord.
So you are not in default.
Matter has been fixed in the ex parte board.
Maybe
But the plaintiff did not take any steps in the court below. However, that
ex parte argument, but has your defense been struck out?
no, my lord.
No.
WS is still kept in record, but that has not been accepted, my lord. Only the delays of 142 days.
Why don't you give the entire order sheet? Then it is easy to understand what is the background.
Of the art.
I do not know your story. You might know your story.
My lord, kindly peruse that.
The 13, order number 13. Order number 13. Yeah,
Tell me one thing.
Yes,
When did you file your, where is the entire order sheet?
that is annexed.
my lord, I
Certified copy is annexed.
all this orders of the certificate copy has been attached to this application, my lord.
After page 43.
My lord, page
1 minute. What is your petition dated 10/12?
my lord, page 6 of the certified copy, WS has been filed along with the petition praying for setting aside the ex parte order.
What ex parte order?
Prior to that, I entered appearance with the vocal adama, but within the time I didn't file the written statement.
Who is
That's
paying the rent.
They are not landlord.
my lord. That is the dispute, my lord.
What?
Not the landlord.
That is the dispute, my lord.
What dispute?
The plaintiff is not my landlord, my lord.
Landlord is Swami Rajput.
Can you challenge the title of your landlord?
My lord, that should be taken
So
in
did
the
you ask for an adjudication of your relationship?
yes, my lord. In the written statement,
Why in the written statement? 7/2?
my lord, as there is no relationship of landlord and tenant, so this suit is not maintainable. That's why I filed the written statement, taking with the ground of maintainability of the suit. But my lord, the written statement has been filed, kept in the record. So,
When did you file the written statement?
my lord, the certified copy, page 6, order dated 10th December 2018. Defendant files WS and also files a petition praying to set aside the ex parte order.
What is the ex parte order? Kindly show me.
Yes, ma'am. My lord,
Where is that application?
my lord, page 5 of the certified copy.
What is the order date?
That is the order dated 12 November 2012, 2018. Today is fixed for filing the WS
12?
by 12 November 2018,
কোথায়?
Order number 6.
page 5 of the certified copy.
Certified copy has been annexed in bits and pieces, so I cannot understand.
My lord,
Clearly,
Order number 12,
order number 6, my lord.
6 December.
no.
No. Order number 6 dated 12 November 2018.
Order number 6.
Page running page, certified copy, running page 5, my lord.
How many pages from your affidavit?
একটু দেখিয়ে দাও।
First is the plaint, page 15, 14. Then
Page 14 is the plaint.
yes,
Thereafter,
I can't find any order number 6.
চেয়ে দেখে নিন।
my lord, or I have annexed the original certified copy, my lord. That's why the numbering has not been made in the original certified copy.
দেখে দিন না।
My order sheet starts with order number 8.
No.
After the affidavit portion,
My lord,
Of-
thereafter the original certified copy has been annexed.
Annexed.
Thereafter,
this one,
yes, ma'am.
Yes.
that starts with order number 12.
Okay.
No, my lord.
Please
Wait.
check from my own.
Yes.
দেখো তো,
এই দেখো।
পরেরটা দেখো, খুঁজে দিই। Call the next matter. Please make way for the other learned advocates to
Yes.
find out. And please, whatever you want to rely on, the application, recalling application, please post. দিয়ে দাও, এইটা দিয়ে দিন। Please sit at the back and do it.
Yes.
Let the learned advocates appear. Yes, next matter. Yes, item 6.
This is my application. I
I'm for the opposite party husband.
the revisional application first taken on. This has come up for the reimposition of interim order. First in
Hear it out if it's a small matter. Yes, what
Yes.
is it?
My affidavit in opposition.
my reply
Opposition reply.
But it's not section 24 transfer.
What do you want from where to where?
Yes, from Howrah to Asansol.
What is, you are the wife?
Yes, I'm the wife.
Howrah to
Asansol.
And where, what is your ground?
My ground is that I'll have to make an arduous journey from Asansol to Howrah in each day, and I stay with my little child who is to be taken care of. My aged parents are not firm enough to take care of that child. I'll have to leave that child every day and travel to Howrah on each occasion and then go back.
Paschim Bardhaman.
Paschim Bardhaman, the
And there are other
Bardhaman
proceedings.
district, my instruction, I have taken
Okay.
a reasonable stand, my client has also been agreed. But if it is in Purbo Bardhaman, the
হ্যাঁ, পূর্ব, sorry, বর্ধমান কোর্ট।
Bardhaman town, yes.
Yes,
I'm
please,
agreeable.
There are other proceedings probably going on before the Asansol court also.
Here,
Let-
also,
let-
the
let-
Howrah court, he has filed
No,
an
no,
application
let-
for alibi.
It cannot be only because everything the wife has filed where she lives, that the
No, no.
husband has to keep traveling. It doesn't make sense. There are no
And it's really in
allegations
the
of
mixed way.
any physical assault or anything, so.
There are
Midway is fine.
allegations of physical assault.
All right, so.
In fact, FIR has been lodged and investigation
Right, I
is
will
going on.
note that.
Yes. And
The wife petitioner seeks transfer of matrimonial suit number 1313 of 2022, pending before the learned additional district judge, fourth court at Howrah, to the court of learned judge, Paschim Bardhaman at Asansol.
yes.
That's it.
Okay. Asansol থেকে পূর্ব বর্ধমান is how, Bardhaman town?
Well, it's just midway from Howrah to Bardhaman and from Asansol to Bardhaman.
From
It's just
Kolkata to
With that,
Asansol, it is
other
4
proceedings
hours.
are
And
pending
Bardhaman
within
is
the jurisdiction of Asansol,
midway.
and it would be difficult for the wife to undertake an arduous journey to contest the matrimonial suit at Howrah. The minor child is also residing with the petitioner. The petitioner would find it extremely difficult to travel by herself and travel by herself, as there was none to accompany the petitioner. It is also submitted that the petitioner feels insecure to travel to Howrah, as there are allegations of physical and mental torture against the husband. Next paragraph. Having considered the distance the wife has to undertake, and having considered the fact that the minor child is with the wife, apart from the allegation of physical and mental torture which have been leveled, this court is of the view that it would be prudent to transfer matrimonial suit number
Yes.
1313
of 2022
to a court outside the jurisdiction of the husband's place of residence. The convenience of the wife is taken into consideration, but this court the court deems it fit to transfer the matter to a place which is not too inconvenient for the husband to travel as well. Thus, the court directs that the matrimonial suit should be heard by the learned district judge at Purbo Bardhaman, bracket Bardhaman town.
125. 125 CR.
Bardhaman town is equidistant from
Reply টা দেখো তো reply তে দিয়েছি কিনা
from Howrah, as also Asansol. It is midway, and the travel time to be would be much less for the wife. Stop.
না সেটা আসবে না
The application, revisional na kintu
No,
eta.
no,
This is an
only one
application
thing
for
your lordship
transfer.
kindly clarify.
Yes.
In Howrah court, the wife has filed one application under section 24 that has been registered as a separate miscellaneous
Yes.
case. But your lordship directs
Including
both.
the miss case.
Yes, yes. Otherwise, that will read.
Including miss case number, Janis.
Number.
the number
Miss case number 27 of 2023.
no that is 125 that is in Asansol.
Nah. Oh, ঠিক আছে, along with the pending application for maintenance pendentility করে দাও.
Yes.
Filed in connection with this suit.
Yes.
Filed in connection with.
It's
the
mentioned in
matrimonial
paragraph 17 the number is
Be transferred,
no, not 17.
but তবে কি
পুরোটা আবার
be transferred নাকি কিভাবে ওই লাইনটা একটু পড়ে দাও.
reply টা দাও আমাকে একবার
Does the court directs?
না নেই
No. That the directs the learned district judge at Howrah, to transfer matrimonial suit number 1313 of 2022, which is pending before the learned additional district judge, fourth court at Howrah, along with the miss case arising out of an application for maintenance pendentility filed by the wife, to the court of the learned district judge, Purbo Bardhaman, bracket Bardhaman town, for disposal. The transferee court shall issue notice to the parties upon receipt of the records, and thereafter the suit shall proceed in accordance with law.
My lady, may I only pray for recording?
Affidavit in opposition and reply are taken on এর উপরে লিখে দাও।
May
Yes.
I bow down to this order? May I pray for only recording of my submission regarding pendency of other matters in
আচ্ছা,
the Asansol court and your ladyship's views on it?
Inconvenient, and it is all, the further ground for transfer is that other proceedings are already pending before the Asansol court.
Regarding Midway, my submission was that my client is not in a employment is in such a way that he has to travel twice in a month to a northeast zone for the purpose of advertisement. So that's why his
ওখানটায়
father
লেখো
has to
যে-
look into. His father is very ill. His father has to look into all these proceedings.
I bow down to the order itself.
Yes, yes, not
Just that
Convey-
recording for.
equidistant বললাম না, ওই
only
husband cannot be made to travel to Asansol, একটা জায়গায় বলেছি।
Yes.
Considering the factual aspects, with regard to the inconvenience of the husband, it appears that he has to travel on account of his employment, on account of his service, and his ailing father has to look after the pending
Proceeding on.
litigations. Hence, a place which is midway for both the parties should be perfect for adjudication of the matrimonial suit. তারপরে ওইসব করে দাও, ওটা বুঝতে-
Extremely good.
লিখে দিও ঠিক
Great.
করে। তো half
Oblige
job
your
হয়ে
ladyship.
গেছে। আচ্ছা,
The-
এখন তাহলে ক্যান ফ্যান পেন্ডিং নেই তো?
Nothing is pending, the affidavit of service will be kept
Section
on.
24
Though they have.
আলাদা কর, সব শেষ করে দেবো।
Great.
Great.
I will do one thing. তোর তো 3:30 ঠিক নেই। Otherwise, section 24, if I could fix at 4:25, it could have been separately, because these are not very long and contested matters. It's just a
415, 425, your lordship can at least dispose of 5 to 10 matters.
Yes.
Yes, because unnecessary they are pending.
2 minutes only
Let us
required
see.
for each.
Yes, all right.
Good.
Yes, one thing, please tell the bar, whatever 24 they have, আমার তো 24 কবে থেকে, 20 সাল থেকে? From 20, 21 and 22, all the pending 24s, if they can give their slips, writing that, it will be much easier for us to segregate, and I will put them in the list.
Very well. We shall.
Yes. 7.
Served their item delivered. But the interim order was till last week of June. So I
I am
mentioned-
for the opposite party number 1. My lord, can one, my lord, is the vacating application? Kindly see the last order, my lord. By suppressing the material fact, interim order was obtained. Kindly, my lord,
1 minute, 1 minute.
yes,
What is
enter
this?
certified
Come
copy
to
of
the
this order,
certified copy.
certified copies of the order.
What is the order impute?
My lord, initially identity
Order-
order passed.
Order impugned,
Sit
order
down,
number,
It is his petition. Let him finish. Yes, Mr. Mukherjee.
Your lordship finally turns to page 27, order number 12 first.
Page 27, order number 12.
Yes. Interim order was, ad interim order was passed initially, immediately upon filing of the
Vacated.
suit.
It
Did
was
not
vacated.
file any petition for extension of ad interim India.
The interim vacated, all right.
Vacated. Order 39, Rule 4 application filed on behalf of the defendant was kept pending. That was not taken up. Now the court says.
Becomes
since it-
infructuous, all
it
right,
became infructuous. So
right.
everything gone. But I challenge this. Immediately thereafter, this order was revived. They filed an 151 application before the court below. That
Mhm.
151 application was the copy not served. On the basis of the 151 application, injunction order was, ad interim order was revived. Nothing was stated as regards what would be the fate of the order 30 and Rule 4 application. I challenge that order before this honor.
My Lord, Honorable Justice Subhasis Dasgupta directed the court to take up the Order 39 Rule 4 application, because that will not create a bar pending the revision application. My Lord, it was not taken up. It went on. On a day, same thing repeated by the court below. My Lord, again on a day, my Lord, order number 28, dated 22nd of December 2022, order sheet. These order and the last order has, both the orders are challenged.
Hearing of the injunction matter along with order 39 rule 4. All right.
Now, kindly see, my Lord, none appears for
Yes,
the
yes,
next
I've
week.
seen.
So none appears, no steps taken, automatically there was no extension.
Till when was the extension given on the earlier order? When is
Earlier order
number
extension was
27?
given till this day.
देखिए order number 27 की है से ताले। Till date is
So no steps taken.
22nd.
No steps taken.
Hmm.
No identity order was there.
Hmm.
Now see the subsequent order. Both the orders are under challenge. Again, the court says, on perusal of the material record, it appears to me that the interim injunction is not vacated till today.
Not vacated, but it was not extended.
It was not extended, means once upon a time it was vacated.
All right. Injunction
A-
application is pending.
That is
It
to be
will
hard
hard
word
under
afresh.
39 rule 4.
Afresh.
Afresh
After setting
finally
aside this order.
decide. Yes, extended ad
And
interim.
well,
yes,
kindly
extended.
fix it, because from day one it is pending.
When is the next date?
Next date,
10th July.
On 10 July, এর এক সপ্তাহের মধ্যে এটা শুনবে। Yes. There appears to be some merit in the submission of Mr. Mukherjee, learned advocate, appearing on behalf of the petitioner. It appears that the learned court below was confused as to whether the ad interim order of injunction was subsisting or had been vacated or had been extended from time to time. It further appears that an order was recorded that the application for modification under Order 39 Rule 4 of the Code of Civil Procedure had been dismissed as infructuous. But once the ad interim order revived on upon consideration of an application under Section 151 of the Code of Civil Procedure, no order for revival of the modification application had been passed. A coordinate bench had directed that the said application for modification should be heard. The learned court fixed dates for hearing of the application for modification, but extended the ad interim order without considering the said application. This, in my opinion, was not the correct process. However, as it is informed to the court that the next date for hearing of the next date for hearing of the matter has been posted on July 10, 2023. Justice would be subserved if the learned court is directed to dispose of the application for temporary injunction, as also you have filed your objection.
Yes,
Along
everything
with
fine.
the objection filed by the defendant and the application for modification under Order 39 Rule 4 of the Code of Civil Procedure, also filed by the defendant within a week from the next date fixed. The time limit is peremptory and the learned court shall comply with the said order. Acha, within a week, আবার এটা তো court to court communication না করলে তো করবে।
Yes, ma'am.
Within a week from communication of this order, on the next day, parties shall be at liberty to approach the learned court below with server copy of this order and pray for listing of the matter and its final disposal. Listing of the application and listing of the matters which as directed by this court and their final disposal. Yes.
My lord, may I take back,
Revisional application disposed of, order impugned is modified to the above extent.
may I
yes.
take back the certified copy
Yes, yes,
by
take it
exchange
back.
of Xerox copy?
দরকার নেই। Next.
The pending can is also disposed of.
Or with the disposal application,
No,
pending
My
application.
lord,
is-
within a week, temporary injunction application will be heard. Temporary along with order 39 rule 4 application.
Temporary objection, order 39, which is also in the nature of objection, all of that will be heard.
Great.
Within a week from communication, on the
Okay,
next day,
sir.
you are communicate to the court, let the court decide.
Yes, ma'am.
এই এটা তাড়াতাড়ি নামি যেগুলো 1-2 weeks করে দিচ্ছি না, আজ কালকের অনেকগুলো অর্ডার ইমিডিয়েটলি যেন ফাইল নেমে যায়। Yes, please.
My lord, it's very unfortunate to me. The copy of that particular order has not been annexed to the
Please give
application.
me a total certified copy from the beginning till the end. I'm extending the interim order for a
Yes, ma'am.
limited period. Done appears on behalf of the opposite party despite service. Affidavit of service is taken on record. Fresh notice along with a server copy of this order be served upon the opposite party. The interim order already passed is extended up to 31st August 30th September 2023. Let this matter appear for final disposal on এই সেপ্টেম্বর বিকেল বেলায় কিছু একটা দাও তো ডেট খালি 11 সেপ্টেম্বর 12 সেপ্টেম্বর খাতাটা আছে সেপ্টেম্বরটা বার কর 12 12 September 2 p.m.
Liberty to file the original certified copy.
Yes,
Yes.
just file the original.
Yes,
Entire order sheet, if it is there, it is easy for us.
Yes.
From the filing of the suit till the last date, please
Yes.
give it to me. The petitioner is directed to file the entire order sheet from the date of institution of the suit till the passing of the impugned order.
yes.
With the disposal of, no, sorry, as the interim order has been extended, can so and so is disposed of. Comma দিয়ে? Yes. 8,
My lord, in this matter, Mr. Parthapratim Roy is appearing for the petitioner, my lord. He's
What
on
for?
legs. I'm for the petitioner, my lord, led by Mr. Parthapratim Roy. He's on legs in courtroom number 13, my lord. May I pray for short passover, my
you
lord?
served?
Yes, my lord. As per the direction served, my lord, 2 is delivered, 1 is left, and 1 is refused, my lord. This is the affidavit of service, my lord.
Left. Who has left? They are contesting together.
Yes, my lord. Decree has been passed against all of them, my lord. This is specific performance of contract, my lord.
What is the order you are challenging?
My lord, by passing the decree, my lord, the petitioner was directed to deposit the deficit amount of consideration money, my lord, within certain period of time, my lord. That was not done. Before the executing court, that prayer was made, my lord, that was turned down. Against that order, my lord, this instant application has been preferred before your lordship, my lord. If my lord takes up the impugned order, that is order number 47, dated,
They are jointly contesting?
yes, my lord, jointly contesting.
Yes. What you wanted to show? Acha, let Partho come.
Yes.
Pass over. এটাকে pass over করে রাখ।
Great.
Ask him to bring the law, the specific relief act.
Yes, my lord.
60, my lord, I appear, my lord, your lordship directed me to, my lord, take out the certified copy of all the orders of the suit, my lord. My lord, it's a long pending
Have you
suit.
served?
My lord, I have served, my lord.
That affidavit of
That
service.
is returned back again, I have served, my lord.
Return back as?
Not known.
Where is that?
My lord, the plaint address, my lord. 23A Hemondra Sen Street, Police Station, Burtala, Kolkata 6, my lord. They're not known, my lord. I have again served, my lord. Kindly gives a fortnight's time, my lord. I will
Where is the certified copy?
Yes, my lord, I have applied, my lord. That's a 2013 suit, my lord. They are taking some time, my lord.
When can you come back?
Not fortnight's time, maybe.
Let this matter appear on 27 July
Wait,
as an under the same heading. No. Service upon the opposite parties as also upon service of this order upon the opposite parties as also upon the learned advocate appearing on behalf of the opposite parties in the learned court below. Now, service of the revisional application also you have not served.
no, my lord.
Then why didn't you serve?
My lord, not known, my lord. They came back
How
again.
it is not known
They,
unless
they
you send
returned.
me.
They returned.
Where is the return affidavit?
Returned, my lord.
Show me the documents that it returned.
My lord, that is not there, my lord.
Why are you smiling?
That is not there, my lord. There is in the chamber.
How can it be in the chamber?
But this because I have again served, my lord. Again, I have served.
It is in the chamber. File is with you. What is this? Take down the learned advocate. Although the learned advocate for the petitioner, Mr. Shaunak, what's your name?
Chonak Mondal, my lord.
Mondal submits that an attempt was made to serve the opposite party. He has failed to, and the service return has come back with the endorsement not known. Learned advocate is not in a position to prove the truth of such statement. It is submitted that the service returns which have been downloaded, the information which have been downloaded are not kept with the file. It is further submitted that fresh service has sought to be effected. Such contention is also not backed by any document. Hence, the court is unable to accept the petitioner's submissions. Fresh service of the revisional application upon the opposite parties, as also upon the learned advocate for the opposite parties in the court below. Let this matter appear on 27th. Affidavit of service to be filed on the next date. In case of non-compliance, the revisional application shall be dismissed.
Wait.
My lord, I am for the petitioner, my lord. On the last occasion, my lord directed me to serve, my lord. I have served. My lord, suit for expeditious disposal, my lord. Last occasion,
Yes.
my lord kindly takes up
What is
on
this matter?
my lord, expeditious disposal, my lord.
Topic se korar ki? Acha, yes. What you want to be oh.
My lord, a suit, my lord, filed by them, my lord.
Ah,
Filed by them, my
file
lord.
directed, no?
Yes, my lord, directed. Directed.
What do you want to be disposed of expeditiously?
My lord, the suit, my lord. Suit.
You have any objection?
Yes, my lord.
Why?
My appeal is pending. They are appearing over the appeal, my
My
lord.
lord, appeal.
My lord,
There
I'll
is
thank-
no.
1 minute. There must be a reason why I asked you to serve me.
Yes.
I'm grateful that my
Otherwise,
lord,
I would have disposed of.
lord, I'm just serving over the order sheet, my lord. Just
It up.
collected order sheet, my lord.
What
My lord,
appeal is
what they have
pending? I
suppressed.
can appeal.
Yes, my lord. Miss appeal, my lord. Against this order which they are coming today, my lord, for this title suit for early disposal, my lord. Against this, my stay has been vacated, my lord. Thereafter, I have gone for miss appeal, my lord. This pending, my lord, before the district judge.
I will direct the miss appeal to be disposed of. Yes, take down.
Order 30, because they are appearing over there, my lord. Order 39 rule 1 is pending also. They have been served, they know everything.
My
But here they have
lord,
suppressed, my lord.
may I
No,
show
no,
the
my lord, not
order
the
sheet,
fa-
my lord? These are
agree.
submissions.
But the main fact is,
From the averments that you have talked about the miss appeal.
that is my only prayer, my lord. That is only prayer, my lord.
That, my lord, I
My lord, in
never
the
got the
meantime, they have
instruction,
sold
my
out the
lord.
property, my lord.
I have not.
Your client should be settled with cost for suppression.
My lord, kindly. She's a my lord, simple lady, my lord. From
No, my lord, not that, my lord. Last time they had appeared before lordship. with another application, my lord. There we have lordship directed, my lord, they should not alienate the property, my lord. Because in the meantime, they have already sold two part of the property, my lord.
Take down.
Their main target is dispose of the matter, they will sell it out. My lord, I am praying for dismissal of
My
this
lord, I
application,
am
my lord.
praying nothing, my lord, for expeditious
My lord, they should have
disposal.
come with their fresh hands, my lord.
But
They have
you
suppressed
should
this fact, my
have
lord.
Suppressed it.
My
They are
lord,
appearing over there, my lord.
my lord, the fact is, my lord, that was not informed to me, my lord.
How are you taking responsibility?
My
It
lord,
is your client.
My lord, I
Is
understand,
it
but,
about you and me? It's not.
my lord, but as I know the client, my lord, she's a simple lady, my lord,
No.
and
Do not try to cover up for these recalcitrant clients who are unfaithful.
it
1st
comes
August
to
23.
order number
My lord,
35, my lord.
39 rule 1 and 2 has been served to them, my lord. We have filed the caveat, my lord. Now, if this is, my lord,
Just tell me one thing.
Yes, my lord.
Suppose there is no injunction in a suit property, right? There is no harm in the suit progressing. Injunction is not a condition precedent to a
no, my lord,
suit.
that is not the fact, my lord. Now, what has happened, my lord? In the meantime, after lordship direction, my stay has been vacated over there in the court below. They are starting.
Where is my direction?
My
There is
lord,
no direction, my lord.
as such, no direction, my lord. There was direction from lordship direction that the suit has to be. They have come into another appeal, my lord.
All right.
Now, my lord, in the meantime, after this order, my lord, my stay has been vacated. Against this order, I have gone for a miss appeal. I have filed for the stay of this application.
My friend is,
Well, no, only prayer is that that miss appeal will be heard out first. But if this is heard out in by chance, my lord,
my lord, kindly comes to order number 35 once, my lord.
It appears that the interim order of injunction which had been passed in favor, temporary injunction application has been disposed of.
Disposed of, my lord.
no, where, my lord? In miss
The
appeal, my
court
lord.
below, disposed of, my lord.
Against that order you have got.
Yes, my lord.
It appears that the order for temporary injunction had been dismissed and the misappeal was filed by the defendant, by the plaintiff being aggrieved by the said order. The misappeal is pending since 2021 and this court does not find any reason as to why the same has dragged on for so many years. When the appeal arises out of an order of rejection of the application for temporary injunction. However, this court directs that misappeal number. But have you got any stay in
No, my
the
lord.
misappeal?
My lord,
my-
they have not served
it
us,
is-
my lord.
My lord, kindly see the order sheet, my lord. They are saying that
My lord,
both copies of memo of appeal as well as the petition under order 13 rule 1 and 2 dated section 1 served to the learned advocate for the caveat, my lord. They have filed the caveat, my lord. Both have been served to them, my lord.
that is here, my lord. Second appeal pending here, my lord. That is a different
No,
case.
my lord,
altogether.
this misappeal I am saying, my lord.
My
They
lord,
can challenge in this order, my
my
lord.
lord, may I,
Kindly see,
my
kindly
lord,
see the
once
order sheet,
comes to my lord, order number 35, my lord.
My lord, now I am
Dated
only see the order number
22nd
3.
Street,
They have filed
2021,
on
my
that,
lord.
my lord.
My lord, once, my lord. What they have done,
My
my
lord,
lord,
so
I
the
show.
caveat, my lord, what they have filed, my lord.
You have been asking for adjournment all through?
Yes,
My lord, no, my lord. In the meantime, thereafter the bench was not sitting, my lord. On 1st August, it is there.
Copy of the memo of appeal here and now.
Right now, I do not have, my lord, because right
My
now.
lord, what happens, my lord,
They have been served, my lord.
kindly
This is the order sheet, my lord.
kindly
last
sees the
portion of
order number 35.
My lord, that have served to you, my lord.
Which
My lord, first page, my lord, last portion. First page, last portion, my lord.
both memo of appeal and application under order 31 rule 1 and 2 read with one way to serve to the learned advocate for caveator. Yeah, it's
Caveat,
there.
my lord, that, my lord, is court
Where
below.
your client didn't say.
My lord, kindly,
Why are you going?
my lord, kindly comes to order 35, my lord, kindly comes to order 35, my lord, it will be, my lord, once, for once.
They have come
My
to
lord,
speedy
comes
disposal,
to
my lord.
order 35, my lord, dated 22/3/2021.
How you are even bothering to stand there and talk to the court when you have suppressed everything?
My lord, I have not, my
I
lord,
really do not understand how you get
my
this
lord,
kind of
I
information.
tender my apology, my lord, but,
You do not.
but, my
You
lord,
should
what,
actually retire from the brief if your client has not given you right instruction.
My
How
lord,
can you support a client who's suppressing things from the court?
my lord, I understand,
You do
but
not understand, sir.
my lord,
and you are
I
not
understand, I understand, my lord.
practice
My
that
lord.
you are going to go on arguing with the court.
My lord, I tender my apology, my lord. That is not my intention, my
Then
lord.
please keep quiet and let the court do the order,
My
pass the order.
lord,
কি বললাম? Has dragged for so many years. It also appears that the plaintiff has taken you are the plaintiff
Where, my lord, there?
in the
he is the
suit.
plaintiff.
Yes, my lord, there in the suit.
Plaintiff has taken several adjournments in the misappeal. The defendant defendant in the suit has also filed an application. Had also filed a caveat in the misappeal, and copy of the memorandum of appeal and the order of and the application for injunction in the misappeal has been served upon the learned advocate for the caveator. This court thus disposes of this revisional application by directing the learned learned district judge Purbo Bardhaman to dispose of misappeal number 17 of 2021 within 2 months from the next date fixed. The defendant is put on notice. Defendants, how many? You are one defendant?
Yes, I am the sole defendant.
Plaintiffs hobe. The defendant is put on notice and is at liberty to file an objection to the misappeal, as also the application under Order 39, Rule 1 and 2. The misappeal and the application for injunction filed in connection with the misappeal shall be directed, along with the objections to be filed, mandatorily within the period as directed herein above. Thereafter, the suit shall proceed expeditiously and disposed of within a year.
I'm grateful, my lord.
This court has not gone into the merits of the case and counter case of the parties. Yes, next.
My lord, I tender my apology, my lord.
Yes, next.
Please, your lordship, my lord.
Yes, yes,
Plaintiff is before your lordship.
yes.
This is a suit for partition and permanent injunction filed by the plaintiff. There is some defects in the, my lord, schedule of the plaint. Because my lord, only defect is that, my lord, that
At
is
which
formal.
stage you asked?
My lord, that is one after, my lord, closure of the evidence. But the explanation has been given, and that is, my lord, formal in nature. That only quantum of land has not been mentioned.
It's at the schedule of the plaint wherein the area of the land
My
has
lord, page 30 is my lord amendment
and
petition.
advocate of the defendant. Number one, this is object states as an
So, my lord, you will not change
Where is your application? Order
page
60,
30.
70?
Page? Page 30, Annexure C, page 30. Paragraph 2 is explanation, and the paragraph 3, my lord, I wants to incorporate. I want to incorporate only the quantum of land.
Area of land 6 decimal appearing after
Yes.
the word Shabik Dag number so and so. Show me your original plate.
My lord. That is, my lord, page is start from page 16 and relevant pages schedule is at page 20. The reasoning of the, my lord, learned court below is that it will change the nature of that. It will not.
Yes, take down. An arguable case has been made out by the petitioner.
Hello,
Uh,
Joshua.
লিখছে? An arguable case has been made out by the petitioner. Prima facie, it appears that only the quantum of land in respect of which partition has been sought for was sought to be incorporated by way of an application for amendment, which was left out in the schedule of the plaintiff allegedly by mistake. Service upon the opposite party, affidavit of service. How many are there? Opposite parties?
My lord,
Petitioners, opposite parties, defendants.
Three
Affidavit
opposite.
of service to be filed on the next date. Let this matter appear on 13th September,
13th.
2 p.m.
13th. Only
Yeah,
thing
what
is,
for the
although it is my suit, my lord, kindly for limited stay because
till 13th
argument.
September.
My lord.
Stay of all further proceedings in title suit number 75 of 2016, which is pending before the learned civil judge, senior division, second court at Asansol,
Wait.
up to 30th.
Up to 30th.
Yes, next. Pocketed কি হলো আজকে? ছুটি নিতে বল, এরকম 2-3টের সময় আসাটা ঠিক না কিন্তু। না না, বাট এটা কিন্তু আমি বলে দিচ্ছি, এই জিনিসটা ঠিক না। যার ছুটি অনেকে সবার পাওনা থাকে, ছুটি নেবে, এ কি? যখন তখন
My lord, I am for the petitioner.
I am for the opposite party number 1.
বাকি opposite party,
My lord, all have been received.
where is your affidavit of service?
My lord, the track report, since Mr. Das is appearing, my lord, I have taken the track reports, all have been served, my lord, they have received. It has been delivered on 12th of June 2023. All,
Yeah, but Mr. Das is not appearing.
yes, now he is saying that for the opposite party.
You should
number
file
one.
an affidavit.
My lord, in course of day, I shall file.
Yes, please. What is this matter?
And so far one is concerned, my lord, he is the main contesting party because he is the plaintiff.
Mr. Das, he just wants to put a roof. Let him do so without claiming any equity. That's all.
Only my submission is,
Yes.
he is trying to legalize the illegal construction
Cannot.
through the, yes, my lord, kindly see.
He
But-
cannot. I will make that observation.
No, what happened? What my objection is, his main contention is, he is doing,
PMOI, PMOIG.
yes.
Yes.
What, no document has been produced before the trial court as well as before your lordship. First, second thing, my lord,
All right.
my specific contention is, his construction is more than 1200 square feet. In the PMI, my lord, 4 to 500 square feet, it would be the PMI scheme, my lord. Four bedroom is he is constructing. My lord, if he is
One thing.
my lord, kindly.
I will help you. I will just say that he will file an application before the court below with necessary documents and the model sketch plan to show how much was sanctioned and what is the drawing under the PMAYG scheme which he had to abide by. If the learned court finds that he can satisfy the court to this extent, then the application shall be allowed only to so that the money does not go back and the money received from the PMOIG scheme is used for that purpose only. If it is found that the construction is beyond the sanction model plan, it will not be allowed. And whatever is allowed,
Only submission before your lordship.
yes,
Kindly direct
no
the,
equity will be.
no, kindly direct the trial court. This is my submission, my lord. Take from the report from the panchayat. Because under the scheme panchayat, under the supervision of the panchayat, it will be done. That's why my prayer before your,
Right, but at this stage, report from the panchayat.
yes,
And another 1 month. Yes, take down.
Difficulties, my lord. In this way, the matter will be delayed and my
But
lord.
Mr. He's right. Show me the model plan, what you have allowed, where is the
moreover, his
sanction?
son is CRPF personnel.
Just take down. The dispute in this revisional application is whether where is the order impugned?
The last certificate. Relying upon the judgment of Israel and Samsir, my lord, this order has been passed. My application has been rejected
whether-
without considering the hardship.
Construction shall be allowed in favor of the petitioners. You are defendants.
My lord, depending
You
on
are
one
defendants in the suit for partition. By modifying the order of status quo passed by the learned
refused
civil judge senior division third court at Midnapur in title suit number 30 of 2023. Title suit number 30 of 2023 is a suit for partition. The said suit, in the said suit, an order of status quo was passed. During the subsistence of the order of status quo, the petitioners filed an application under section 151 of the Code of Civil Procedure, praying for permission to raise a construction. It was stated that the order of status quo had been passed when partial construction of a structure on plot number 37 had been completed from the funds received under the PMAYG scheme. The prayer was that unless the roof casting was allowed, the construction would suffer serious wear and tear, and the iron rods used for such construction would be left exposed. The learned court below rejected the said application on the ground that the
My lord, my objection page 22 and 23, my lord.
The last page of the impugned order, second paragraph. In view of the aforesaid, I am of the opinion, defendant number 1 to allow to complete the construction involved in dispute. Situation may become irreversible, and which is the observation of Israel versus Samson. But here, my lord, I have prayed for not to claim any equity. Therefore, this principle will not be a bar. In the application, I have specifically stated, it is at page, my lord.
On the ground that if the defendants were allowed to complete the construction on the suit land involved in the dispute, the situation may become irreversible by the time the dispute was decided finally and would preclude a fair and just decision in the matter. Next paragraph. Mr. Das, learned advocate, appearing on behalf of the plaintiff. How many plaintiffs?
One.
Submits
Yes.
that it's a defendant numbers 1 and 2. Petitioners defendant numbers 1 and 2. ওটা একটু লিখে দেবেন, অনেকগুলো আছে. Submits that under that not a scrap of paper had been produced before the learned court below who could justify the claim of the defendant numbers 1 and 2 that the construction was undertaken under the PMAYG scheme. The model plan also, or the sketch, model plan oblique sketch, usually supplied to the beneficiaries under the scheme, was also not placed before the court. Under the garb of undertaking a construction from funds received under a beneficial housing scheme, the defendant numbers 1 and 2 were raising a comparatively substantial construction, which could not be raising a substantially large construction, which could not be under any scheme. Next paragraph. From the order impugned and from the application filed by the defendant numbers 1 and 2, it appears that no specifications of the area of the construction, the date of receipt of the benefit, the date of disbursement of the installments, the bank account through which such installments were received have been mentioned in the application. The size of the construction, the model plan which was supplied for construction under the scheme has also not been mentioned. Hence, the prayer of Mr. Mahato that unless the construction is completed, the benefit under the scheme would be lost, would expire, and the money would go back, is not accepted by the court at this stage. The order impugned is set aside with the following directions. A, the petitioner will file a composite application along with evidence that the petitioner is a beneficiary under the petitioners, or any of them are beneficiaries under the PMAYG scheme. B, supporting documents with regard to allotment of funds, enlisting of the beneficiary, allotment of funds, receipt of the funds in the bank account of the beneficiary shall be annexed to the said application. C, the model plan supplied, which would indicate the area and the nature of construction under the scheme, shall also be annexed. Thereafter, a certificate from the block development officer that one of the petitioners are beneficiaries under the scheme shall be filed. Upon filing the application along with all the documents as indicated above, the learned court below shall consider the fact whether the petitioner was a beneficiary under a scheme, and if it is found that the construction sought to be made was exclusively limited to the model plan and only from the money received under the scheme, the court shall allow such construction in the presence of an advocate commissioner at the cost of the petitioners. If it is found that the factors which were directed to be the documents as directed to be filed by this court are not filed, and there is a question, there is a doubt as to whether the petitioners or any of them were beneficiaries under the scheme, or were constructing strictly or not or were constructing strictly in accordance with this model plan or were not constructing. The court shall not allow any such construction. If construction is allowed, the same shall be exclusively in terms of the beneficial scheme and the model plan. The petitioner shall not claim any equity in respect of the said construction. Full stop. Construction will abide by the result of the final adjudication of the partition suit. The order impugned, set aside করে দিচ্ছি, yes, disposed of.
Only one thing, my lord, kindly allow me to file my objection against the
application all the contesting parties shall be entitled to file their written objection to the said application. Yes.
May it please your lordship.
Yes.
Lord, this is against an order of the arbitrator. Lord, what happens is the learned arbitrator, after Lord, conclusion of arguments, almost wants us, Lord, to file an arbitral award between Lord, two parties. An arbitral award, let's put it this way, Lord, which is hit under section 42A, Lord, of the Arbitration Act. Arbitration Act says, Lord, only if for an implementation of an award, Lord, it's only then, Lord, that an award between two parties, Lord, can be produced in a collateral proceeding. Otherwise, Lord, it is hit by, Lord, confidentiality. Have a look at 42A.
এখানে arbitration conciliation act আনা হয়েছে সরু থাকবে এখানে থাকার অনেক আনতে বলেছিলাম তো you have an extra copy
Lordship takes
আছে না আছে আছে
Reproduced at 17.
yes
notwithstanding anything, my lord, kindly got it. Notwithstanding anything contained in any other law for the time being in force, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings except award where its disclosure is necessary for the purpose of implementation and enforcement of award. Lord, here, taking of evidence is closed. Arguments have commenced. Their arguments are almost over. Then they file an application saying that I want an award, which I got between Milord. There was an award between MBL and Milord DVC. I say I can't disclose it because that's hit by 42A. The learned judge says, Milord, that there is an intrinsic thing between the parties, so there is no question of confidentiality. And if I, Milord, produce it, then my confidentiality, whatever it is, it goes. So I have to, Milord, challenge this order before your lordship. Milord, there are lines of decision where, Milord, in an arbitration proceeding, Milord, the powers under 227 have to be used very sparingly. But Justice Shobhoshachi Bhattacharya held, Milord, in a very recent decision, where, Milord, if it goes to the root of the matter, Milord, the constitutional powers cannot be taken away.
that is with regard to what
Arbitration.
forum
No, arbitral proceedings. I had the occasion to argue, Milord. It's a reported decision. From L. Chandra Kumar, Milord, the constitutional powers cannot be taken away by a
all
statute.
right
But your lordship will use it sparingly. No, there is no alternative remedy, Milord. Because today, if I produce it,
37
that's later, after the award. Looks to 37. Sees? Have a look at 37. Section 8, Section 9, 34, 16(2).
17
Yes, Milord.
so this arbitral award where is the order in
Yes. Kindly looks to the 1.5, should have been right at the end, but it's at page 15. We take up this point, Milord, at page 17, 1.7.
Or if your lordship wants to see the facts, your lordship may see at page
How
16,
do I
paragraph
have
3,
jurisdiction?
227.
Where is the arbitration being held?
No, this is of Calcutta. The seat, my lord, might be, my lord, there. ওটা একটা- my lord, this is the parties are, my lord, between DVC and Macintosh, all the contracts, everything of Calcutta, just the seat is
of
there.
arbitration is.
Section 16, my lord, your lordship knows that where the actual cause of action is Calcutta. And there is another revision
With
application,
Everything is on, with regard to the seat of arbitration, no?
but where the first, my lord, no, my lord, respectfully, where the first, my lord, cause of action arises, that's the place. My lord, there is a revision application pending in this matter before your lordship and entertained. But only because it's an MSME that the arbitrations will not happen in Delhi.
I need to be convinced about the
Very
jurisdiction.
well, I'll convince your lordship on that as well. I'll convince your lordship on that.
Because as I do not know much, but what I have understood is that the jurisdiction in cases of certain aspects from the arbitration.
I'll tell your lordship. Because what
proceedings
happens is,
of arbitration.
I'll tell your lordship. A dispute arises
This
between.
is not a writ petition that a cause of action will be taken as when
No.
the parties decide.
No. X and Y, my lord, are arbitrating. An MSME. Suppose an MSME. An MSME will always have, my lord, its seat of arbitration in Delhi. But the parties, the whatever the cause of action arises, my lord, is in Calcutta. So that's why the Calcutta courts, my lord, get jurisdiction from there. There are decisions on that. That's not a problem, my lord. I'll show you, lord. I'll convince you, lord. Very well. Tomorrow I'll come and না, লর্ডশিপ জানতে চাইছে, I'll explain. কালকে না কেন? কালকে on করে। My lord, lordship pleasure to keep it on Monday.
Want on Monday, all right, not this week.
The আগের arbitration টা
One thing,
Yes,
this arbitration, the award that they want production of, that is between the same parties.
No. I was one of the
Valley
parties.
Corporation and
I was one of the
you are for Damodar Valley.
No, I am from Lord Macintosh,
Macintosh.
MBL. And
So
the award was
Macintosh
between,
and Damodar Valley
Yes.
was sought to be produced.
Yes.
But Mr. Chatterjee,
my lord,
42
yes,
A
A,
says that
What?
arbitral institution and the arbitrators shall maintain confidentiality of all arbitral proceedings except award where its disclosure is necessary.
for the purpose of implementation
So
and
once an
enforcement.
award is published, what is the confidentiality?
That's what they say. That's what the law is. Only for
An award.
implementation and enforcement. Nothing beyond that. Implementation and enforcement. Nothing beyond that.
All right, let me hear you on the jurisdiction part, then I will. Thank you.
Oh, my lord, acha, very.
You want to serve and come back?
That's what I was
And that
thinking.
makes sense.
That's what I was thinking.
That is service. I'll keep it a short. Where is their office?
My lord, very soon, my lord, in August. In August. Your lordship may direct us to take an adjournment there, my lord.
Subject to the keeping the point of maintainability of this revisional application open, let this matter appear in the list on
Any day, your lordship. My lord, service, this will come from my lord DVC. And
That is
the
the
lawyer
only-
is in Delhi. I'm sorry, Driplex in Delhi. So I'll take at least 3 weeks' time.
the point of jurisdiction open. Okay. Keeping the point of jurisdiction of this court open, let this revisional application appear on
যাচ্ছি কোথায় ওখানে যাচ্ছি তো appeal চলবে
20th July, 2 p.m. To
20th
come. Send it immediately by speed post, it
ঠিক
will
আছে।
come. Service of the revisional application upon the opposite party. Affidavit of service to be filed on the next day. No.
my lord, if
When is the next date? please?
I'm not too sure, my lord, if there is a date, my lord, we pray-
The petitioner may pray for an adjournment of the proceeding in the meantime before the learned arbitrator.
grateful, your lordship.
I'm for the petitioner.
Yes.
My lord, I am led by Mr. Ayun Banerjee. He has not yet come. I am praying a short
Where is
pass.
he? আর কখন আসবে? 12:30 বাজে।
There is,
Lordship,
difficulties, my lord, personal
ছুটি
difficulties.
নিয়ে নিতে বল।
Lordship had taken up the matter on the last occasion.
Mood হয়, কাজ করে। But I have noticed that if I did not come to court by 10 to 10:15, I just didn't have that, the tuning went off.
Lordship had taken up the matter on the last occasion. Lordship expressed Lordship's mind that a leave.
Oh, WS. কত টাকা cost দিবি?
No, not this one, my lord.
Not
This one.
WS.
This was, my lord, a leave was, my lord, a suit was filed.
They have filed
The suit was filed.
তো অসুবিধা কি?
I'm the petitioner. বলো দিদি।
Yes,
My
I
lord,
heard you anyway.
last occasion, your lordship wanted to show the order of the previous matter, my lord, which we have allowed the contest with it is permitted to withdraw the matter with a liberty to file a fresh, my lord. They have last occasion they have stated that no liberty was given challenging the for such reason. This is the
The
order
suit
of
was
the-
withdrawn by them
Yes,
without
but
giving any
file a-
opportunity to the defendant, my lord, to file
my lord.
to file any objection in that regard.
Their suit they
The
want
liberty was granted to them by just
File
one page order. My lord, kindly seize that order.
I'll dismiss
My lord, filed a subsequent suit. I had taken the point in the subsequent suit, my lord,
that
that
is even more bad. I should impose custody.
no, my lord, kindly.
They filed a suit, they wanted to withdraw their suit, court allowed it. It is between the court and them. Who are you to come in a
Withdraw, my lord. If only withdrawal, I cannot object. Withdrawal with a liberty. That part, my lord.
So that is a consequential thing. I will withdraw and I will not file any suit.
My lord, causes must be shown, my lord.
That you don't have to worry.
My lord, kindly consider, my lord. My lord, that point must be taken, my lord, in the subsequent suit, my lord, by me. My lord, subsequent suit, my lord, no order 7 to 11 was filed. Nothing was filed, my lord. Straight away, this revisional application was filed, my lord. My lord, kindly, my lord, let's me, my lord, take this point up.
There is a
The last occasion, my lord, kindly grants me leave,
my lord.
Lordship, otherwise, my lord, kindly considers, my lord. On the last occasion, it fell from your lordship, my lord. That,
Cannot be res judicata. What order 7 rule 11 you will file? Saying what?
my lord, that point was, my lord, not, my lord, I was not given that opportunity to contest that
You are
application
not
every
required
time.
to. It is between the court and the plaintiff. Court is convinced that they wants to withdraw, he will be allowed to withdraw.
My lord, kindly,
And
my
withdrawal
lord, takes up the order.
consequences is the natural consequence of a withdrawal is a liberty.
My lord, kindly
Where
takes
is
up.
the order? Give me. Hey,
Kun
give
order?
me the order,
The order
liberty.
I have-
My lord, that order is annexed.
No,
Oh, it
It's,
is.
I have
with the liberty to
given
file,
it.
right? My lord, that order is annexed, my lord. OS 39 of 22, order dated 21st of December, my lord.
What has he done? They have withdrawn and filed in another court.
Yes, my lord, they have withdrawn, my lord. Kindly, my lord, takes up that application, my lord. Learned advocate for the plaintiff submitted that he has filed a suit on such and such date, praying for eviction and recovery of first position, and this suit is fixed for admission hearing. Learned advocate also submitted in the prayer of the suit, he has not prayed for declaration, so he has prayed for withdrawal of the instant suit.
Right.
Hard considered on perusal of the case record, application and submission of the learned advocate, it appears that the plaintiff has not prayed for declaration in respect of the scheduled property. As such, he wants to withdraw the same allowed. My lord, no presence of the defendant.
Admission stage when the plaintiff is filed.
Defendant already filed their wakalat now, my lord.
Doesn't
Kindly,
matter. Take down.
my lord, let's me, my lord, keep this point open, my lord, in the subsequent.
In the subsequent suit is another suit in another court. You will raise that liberty was not given, having failed in the High Court.
No, my lord.
What the word bar?
My lord, subsequent suit, my lord.
Nothing.
My lord, order 7, rule 11, my lord, that I can file, my lord.
No, so that you file at your own
There is no liberty.
wish and merit, and then that gets
No, only my lord
dismissed.
consider.
5 years, then it will be rejected.
But there is no liberty. in
My lord,
nature.
only my lord keeps that point.
No, nothing will be kept open.
Yeah,
Take
আগের
down.
দিন তো
আগের দিন আমার এই অর্ডারটা ছিল না।
আগের দিন তো order টা annexed।
And can you ever stop anyone from filing any suit anywhere? and this is a suit in another
No,
court.
I can take the point in the subsequent suit.
No,
If
you
that is
cannot
my lord
take
filed,
any
my lord, in a.
You've taken your WS. You don't need that liberty from me, right? Rest barred by res judicata, waiver, acquiescence, estoppel. First paragraph. The revisional application is directed against an order dated December 21, 2022, passed by the learned civil judge, Junior Division, First Court, Tomluk, Purbo, Medinipur, in OS number 39 of 2022. By the order impugned, comma, the order impugned has been challenged by the defendant in the suit, who had just entered appearance by filing a wakalatnama, and the suit had not proceeded therefrom. According to the defendant, the learned court below erred in allowing defendant oblique defendants. The learned court below erred in allowing the petitioner to withdraw the suit at his own risk with liberty to file a
My lord,
fresh.
subject to correction, my lord, they have not challenged that order. Kindly,
My lord, the
go to
order-
page 9,
Order
my
of the
lord, they have
subsequent is
already
challenged.
challenged the order of the 5th April 2023 in the subsequent suit, my lord. The prayer portion, they have not challenged that order, my lord.
Order dated তাহলে April 5, 2023. এখান থেকে তাহলে লিখবেন না, এখানে ভুল লিখেছে। Passed by the learned civil judge, Senior Division, First Court at Tomluk, Purbo, Medinipur, in title suit number 10 of 2023. What is that order?
They for admission of this
Well, that
present
order-
writ petition, present suit, my lord. The first order of that.
No, first order, no.
Present. Ad interim order. Ad interim
Is it an
injunction.
eviction? So, that's
Ad interim injunction.
which order number? What the?
8, order number 8, 5th April 2023.
ওটা আমি তো খুঁজেই পাচ্ছি না।
The last order, my lord, title suit number 10 of 23, the last,
From the last,
okay.
the second page. my lord.
second last page is starts, my lord, ends on the last page.
Now we date the 5th.
By the order impugned, the ad interim order of injunction was extended. The defendants filed the application of the defendants for extension of time to file the written objection and the written statement were considered and allowed. June 13, 2023 was fixed for written objection to the application under Order 39 Rules 1 and 2 of the Code of Civil Procedure, as also written statement by the defendant numbers 1 to 4. SR and AD of defendant numbers 5, 6, and 7 was also awaited. The court does not find any reason as to how the petitioners can be aggrieved by the said order. An interim injunction was passed. The petitioners contested the proceeding. The petitioners sought time to file their written objection and written statement. At this juncture, the contention of the petitioners that the earlier suit was wrongly allowed to be withdrawn with liberty to file afresh is wholly misconceived and contrary to law. The petitioner, the plaintiffs had filed the opposite party kojon. Anyway, the plaintiffs had filed a suit being OS 39 of 2022 for eviction and recovery of khas possession before the learned civil judge, Junior Division, First Court at Tomluk, Purbo, Medinipur. At the time of admission hearing, it was prayed that the suit be allowed to be withdrawn with liberty to file afresh, as the prayer for declaration, which was essential to the suit, had not been made. The learned court allowed such withdrawal and with liberty. The contention of the defendants that the withdrawal could not have been permitted without allowing them to contest the same is not acceptable. Said order was never challenged before any forum. The subsequent suit was filed by the petitioner in a different,
Filed by the opposite party.
by the opposite parties in a different court
My lord, for declaration, local position and permanent injunction. No prayer for restoration of position or eviction.
with other prayers. The said suit has proceeded and hence the revisional application is dismissed. The parties are at liberty to contest the suit strictly in accordance with law. The parties, the petitioners. Now, thereafter, the court title suit was filed, sorry. Title suit number 10 of 2023 was filed before the learned civil judge, senior division first court at HON'BLE, with some alterations in the prayers. Parties are the same.
No.
Not all parties, I don't think.
Partition.
The said suit shall proceed in accordance with law. The petitioners can contest the suit. Is at liberty to contest the suit and take all points as may be available in the as per law.
Grateful.
I'm led by Mr. Banerjee.
Give his name.
I am also led by Mr. Vaid.
Yes, give. Next.
My lord, may I please your lordship, my lord? My lord, this is, my lord, against the order dated 3rd May 2023, my lord, passed by the learned court below Alipur, 2nd Munsif, my lord. Well, I tell your lordship, my lord, this is a suit, my lord. I am the plaintiff petitioner before your lordship, my lord. It was a suit, my lord, for settlement of accounts, recovery of money and injunction filed in 2011.
What happened?
I tell your lordship, my lord, if your lordship kindly comes to the order impugned under challenge, my lord, defendant's witness was closed. My lord, for better understanding of this order, if your lordship kindly reads from the order dated 16th December 2022, my lord, order number 119. 3 orders, my lord. Lordship will understand.
Yes, which one? First you want to
Order
show?
number 119, 16 December 2022. My lord, the entire order sheet is there, my lord. It's very important, my lord. That is why I brought the entire order sheet. Plaintiff files Hajira, defendant files a time petition, none moved.
Time to show that there is any date fixed for hearing today from the Honorable High Court. Hence, the time petition is rejected on perusal of the court as the final opinion is given today from the conduct of the
It's, my lord, trying to day Havena, that will
so
be.
DW was rejected.
The defendant's witness was rejected because, my lord, on several occasions they
They did not
obtained
come.
time.
All right.
Trial was begun, my lord, my witness was completed. Now, my lord, if your lordship kindly comes to the next page, very next page, my lord. On 5th January, my lord, by way of a put-up petition, my lord, they filed an application under Order 18, Rule 70 for recalling the witness. Very well, my lord. Now, my lord, that application, my lord.
Whom? Themselves.
Themselves, my lord. That application, my lord, was heard. And now, if your lordship kindly comes to order number 124, dated 5th April 2023. Very important order. 5th April 2023. As a last chance, one final opportunity was given to them upon payment of cost,
Cost of rupees
3,000.
Yes.
Now, my lord, the order improved. Now, my lord, on that day, what they do, my lord? But that's the very next page, 3rd May 2023, of the last page of the certificate copy. On that day, my lord, it was the defendant's witness as a last chance in terms of the earlier order. What they do, my lord, they pay the cost and they move an application, my lord, under Order 6, Rule 17. Learned judge keeps that hearing of that application. And so far as the last chance of the defendant witness is concerned, it's in a limbo. No observation, nothing, my lord. Now, my lordship knows Order 6, Rule 17, you file as a matter of it gets allowed, amendments. But when the trial has begun, my lord, from the very,
No, but he has not passed any order. He has kept it for hearing.
My lord, defendant's witness was last chance on that day. He did not adjourn it. There
Can
was
the
no
court
petition.
shut out anyone, or for that matter, can I also prevent a party from filing an application under Order 6, Rule 17?
My lord, then it has to be said that both the applications are to be there, and my lord,
Applications.
my
only
lord,
one application.
my
Order
lord,
6, Rule
matter was fixed for argument. They filed
agree.
order 18, rule 17,
I agree.
witness was recalled
Yes.
as a last chance.
It is, even if I accept that, yes, maybe it is a ploy to delay the
My
matter
lord.
by filing this.
My lord.
None of us can really stop the parties from filing an application.
I can understand, my lord, but
Now,
this,
whether it will be allowed, let the
that's
court
a,
decide.
my lord, well, so far as the defendant's witness as a last chance is concerned, no observation, nothing.
Obviously, because now this will be heard first. That's why. So I'll allow you to take your objection and you do finish it off. The points which you are raising before me, you will raise over there.
What I was praying before your lordship, my lord.
I will say that this application, defendant's evidence, everything should be completed within 2 months.
May I, my lord? What I suggest, my lord, subject to your lordship.
Yes,
my lord.
yes.
My lordship will direct me, my lord, to serve them. My lord, because I have annexed their order 6, rule 17 also. And my lord, so far as order 6,
I can't decide that.
my lord, may I, my lord, may I, my lord. What I am on is, my lord, now, my lord, the trial has begun, my lord. Now, my lord, order 6, rule 17 say it is before trial, okay, it's permissible. But when the trial has begun, now, as a matter of right, that order 6, rule 17 will not be allowed. You have to show
What is the
due
nature of
date.
amendment?
My lord, they are saying, my lord, in 2007, 2000, everything was with them. It's all the
Let's
case.
be decided. You take that point. I will not decide
But
that.
then, my lord, that observation has to come down from
Take
your
down,
lordship, my
yes.
lord. And my lord, the matter is fixed on 7th of August.
All right. I
Let
will
it be
hear.
heard on that
You
date,
file
my
an
lord.
objection, it will be heard.
In the meantime, my lord, I'll file.
Take down. The plaintiff, no? You are the plaintiff.
My lord, I'm the plaintiff.
The plaintiff in a suit for what is it? Eviction suit.
No, my lord, it's a suit, my lord, for settlement of accounts, recovery of
In
money
a-
and injunction.
In a suit for settlement of accounts, recovery of money and injunction, has filed this revisional application challenging an order dated May 3, 2023, passed in title suit number 20842 of 2011,
11, my lord.
comma, which is pending before the learned junior civil judge, junior division, second court at Alipur. It is contended that the learned court below, next paragraph, had fixed June 26, 2023 for hearing of an application for amendment of the written statement filed by the defendant at the stage of arguments. And when the evidence of DW had been allowed by the court as a last chance, Mr. Bose, next paragraph, learned advocate appearing on behalf of the petitioner, submits that the series of orders which were passed in the said suit would indicate that due to negligence and laches on the part of the defendant, the learned court below had once closed the evidence. Thereafter, such order of closure of evidence was recalled upon payment of cost, and the DWs were given were allowed to adduce evidence as a last chance. Once such upon payment of cost of rupees 3,000. On the date when the evidence of the DW was to be recorded, an application under Order 6, Rule 17 of the Code of Civil Procedure was filed. Stop. By the defendants. And how many defendants are there? More
Look,
than
there
one
are 2 defendants.
defendants. And the learned court, instead of initiating the evidence of DW, rejected the application under Order 6, Rule 17, fixed the application under Order 6, Rule 17 of the Code of Civil Procedure for hearing, and the defendant plaintiffs were directed to file the written objection. Next paragraph. Although the court appreciates the agony of the petitioners in view of the delay which has been caused in disposal of the revisional application, disposal of the suit, which is pending since 2011. This court cannot prevent a party from filing an application if, in terms of the provisions of law, the merits of the application, of course, will be decided by the learned court below. But Mr. Bose's prayer that this court should stop the defendant from filing applications only to delay the process cannot be accepted at this stage. However, this court directs that the application under Order 6, Rule 17 of the Code of Civil Procedure must be disposed of on the next date fixed in the by the learned court.
That is 7th August.
So that is August 7, 2023. The objection to the same shall be filed and served upon the learned advocate appearing on behalf of the defendants in the learned court below within 2 weeks from date. After disposal of the application for amendment of the amendment of the written statement, the evidence of the DW should be concluded within 3 days. Thereafter, the suit shall be disposed of within the following 4 months.
I'm grateful to you.
Yes. আচ্ছা একটা লেখো যে although Mr. Bose invites this court to decide the issue as to whether such application for amendment could be filed when the matter was fixed, when the suit was fixed for arguments. Although Mr. Bose invites this court to decide the issue as to whether the application for amendment could be entertained at the stage of arguments with when the facts sought to be incorporated were already within the knowledge of the defendants. This court is of the view that such issue has to be decided by the learned trial court for whom such application has been filed.
Has to be, my lord.
তারপর লিখে দাও this
Because Order 6, Rule 17 normally allowed.
The merits of the application filed before the learned court below, as also without going into the merits of the suit. Yes.
I'm grateful, man.
You know, 24, 25 and 26 are really identical matters. If your lordship takes up 25, I think, my lord, 24, 25 and 26 can be disposed of, my lord, by a common order.
Who is for 25?
But I'm appearing in all the matters for the principal opposite party. Opposite party number 1.
For the bank in 26.
Yes.
My lord, very, very.
One simple thing, my lord. Certain documents and papers which were before the trial court, those have not been supplied with the application.
You have.
My lord, this is not.
But I have.
This is, my lord, a revision, my lord, against some, my lord, particular.
I have.
So if they are part of records, they can be looked into.
My lord, may I just, my lord, before your lordship looks into the record, just, my lord.
25 people are there. You are there.
Yes.
You are the bank.
No.
I'm the bank.
In all matters.
I'm only in 26.
All right.
My lord, let me just tell you, lordship, what happened. My lord, there is a property that is transferred by, my lord, the respondent number 1, Punalur, to, my lord, Lindsay, which is now known as Kam. That is the petitioner before your lordship. This property was transferred in 2003 by registered deed of conveyance. The registered deed not only conveyed the property, but also, my lord, all choices in action or actionable claims, because at that point of time, there were, my lord, certain requisitions of portions of the property, my lord, for which compensation cases had been filed. So, my lord, that is a transfer. That is, my lord, in a registered deed. My lord, I don't think, my lord, that can be disputed. In fact, yes, kindly just take up this, my lord, because this has, yes, 25. So, my lord, the basic thing is, my lord, transfer of property in 2003 with all, my lord, actionable claims by a registered document. Now, my lord, in 2010, my lord, this is reaffirmed because there's a change in management of, my lord, the respondent number 1 company, Punalur. But at the time when the conveyance was made, there was some commonality between the management of Punalur and Lindsay, which is now come. Thereafter, in 2010, the lion's share, the majority shareholding in Punalur was transferred to another group. That group comes and enters into an agreement and reaffirms the transaction and says, yes, all actionable claims have been transferred to you. You pursue the claims, whatever monies come, you receive it in one bank account that we have designated. Now, the things were going on peacefully. After 2010, nothing really happened except the money started coming in 2021-22. Now, they had also given us power of attorney, which has now been affirmed by the High Court. Powers of attorney asking us to operate the account, asking us to receive the monies, asking us to pursue the cases, everything. Now, so far as that is concerned, no dispute except that suddenly money starts coming in from the compensation case and quite large sums of money. At that point of time, there are 3 suits that come to be filed. I'll not get into the details of the suit. One is a suit where my learned friends filed, where they said that today you cannot allow the operation of the bank account except by persons who are authorized by Punalur, because we had been authorized to operate that bank account. We had filed a suit saying that you allow us to operate the bank account and don't shut it down, because there was an attempt to close down that account. And then another suit is filed by my learned friends challenging the conveyance of 2003. 2003 conveyance challenged in 2021. Now, at the end of the day, what has happened is, in the first suit that my learned friends filed saying that no one else should be allowed to operate that bank account, we file an Order 7 Rule 11. But in our suit, where we say you can't shut down the account, they file an application, a counterclaim, which challenges the agreement of 2010, which has ratified the conveyance. And then there's another suit, which is filed in 2022 by my learned friends, where they challenge the conveyance. Now, in their suit, the 2 suits that they have filed, and in the counterclaim that they filed in my suit, I file Order 7 Rule 11 applications. I try, my best to get the application heard. I cannot get it heard. I come to this court. This court, passes an order directing the application to be heard and decided. Heard and decided. Now, in the meantime, what has happened, there were interlocutory proceedings in these suits. My learned friend's contention was that this conveyance is fraudulent, the agreement is fraudulent.
So in item 25, what have they challenged?
Kindly,
That is the suit for what?
yes, now item 25, the suit is, my suit saying that you cannot stop the account.
That is your suit.
That's right. But they have filed a counterclaim there.
Right.
Which is where I filed the Order 7 Rule 11.
25 is our suit. We have challenged the
That's it. 25 is it. Now, in that, my learned friends have filed a counterclaim challenging the agreement. I filed an application under Order 7 Rule 11, saying that the counterclaim has to be dismissed. Amongst other things, on the ground of limitation. Now, these, rightly, wrongly, these applications were directed to be heard out by this honorable court. When I go to the court and press this application, my learned friends come up with an application saying that, look, the interim order says that, yes, the entire suit, the basis of the claim, this is all completely fraudulent because you have transferred everything. But there's a tax liability. Because if today the money comes into the name of Punalur, the tax imposition will also be in a Punalur. So you secure their claim to the extent of about 9 crores of rupees. That is carried in appeal to the Supreme Court. The Supreme Court passes an order, which I must show your lordship first. Kindly have a look at page 332. 332.
So when your Order 7 Rule 11 to the counterclaim was heard, they came up with this.
Yes, saying that, no, you can't hear that application under Order 7 Rule 11. I'll just show you lordship 3 orders. Kindly see the order of the Supreme Court first. And this is in chronological point of time.
Page?
Page 332. This is a common order which will apply to all the matters. 332 annexure,
Yes, all right.
yes. Now, kindly allow me to place it. We have heard the counsel for the parties. We direct that insofar as direction given in the impugned order dated 5th April 2022, that the respondents would furnish security to the satisfaction of the trial court for 9 crores 5,70,001.50 is concerned, the same must be furnished within a period of 2 weeks. The security is to be furnished to the satisfaction of the trial court and would be solvent security, which can be encashed and enforced in the case of default. Insofar as the balance amount of such and such is concerned, the said amount would not be withdrawn. If any further amount is deposited in the bank accounts in the IndusInd Bank, which is the subject matter suit, amount would not be withdrawn by any party without any permission of the court. Respondents state that they would be disclosing the compensation received from the land acquisition authorities as income in their taxable returns. The respondents file an affidavit to that effect before the trial court. Said affidavit would be without prejudice to rights and contentions of the appellant. If any tax liability arises in view of the fact that the compensation has been paid or made in the name of appellant, the respondents will indemnify the appellant. So, my lord, this was really security for the tax. Then, my lord, we further clarify that the observations made in the impugned order would be taken only for the purpose of disposal of the appeal and would not be treated as binding findings. The trial court would determine the rights and pleas raised by the parties before this court in accordance with law and based upon the evidence available. We also clarify that the other proceedings between the parties pending before the trial court and any other proceedings would be decided in accordance with law. These include the Order 7 Rule 11 applications which were pending at the time. Then your lordship will kindly see, because this order was passed on 26 September 2022. Because we could not get our Order 7 Rule 11 applications heard, we approached this honorable court. Kindly have a look at the order at page 329.
Against which order did you go up to the Supreme Court?
Yes, my lord. That is an order of the division bench. I shall hand it up to your lordship and let me carry it out. Appeal from my lord, the City Civil Court. I shall hand up this copy of the order to your lordship. If your lordship will kindly see from page 20 onwards, I think the matter will become clear.
Page
20.
This compensation is which? A land acquisition compensation?
Requisition.
So you were allowed to contest that proceeding in the name of Punalur?
Yes.
At your expense?
Yes.
Means that compensation.
All compensation. And I have done so for the last 20 years.
Okay, LA case number decided, 27 crores.
Yes.
Oh, so the tax liability arising out of that compensation money was asked to be kept?
Yes, and my lord, we have said, if your lordship sees page 22, the last two paragraphs, at the same time, Punalur cannot be made to suffer for income tax payable on the compensation amount. As Punalur is not receiving the money and accordingly it cannot be treated as their income.
So Punalur, before the division bench, they claimed the entire acquisition money.
Yes.
All right.
And now my lord, division bank says that, my lord, if your lordship sees, my lord, we have said that we are willing to reimburse Punalur for any, my lord, of these monies.
Return the sum of 9 crore 5 so and so.
Yes. You kindly see, my lord, the last paragraph at page 23. Well, here also the learned my lord division bench directs that my lord, the Order 7 Rule 11 applications will be heard and disposed of. So, my lord, there are two separate things. One is to, my lord, secure, my lord, what could be their tax liability, and the other is, my lord, Order 7 Rule 11. Now, my lord, after this, my lord, your lordship has seen, my lord, the Supreme Court order. My lord, Supreme Court says that you will decide all other applications. Then, my lord, we approach this honorable court in revision. This honorable court, my lord, passes an order, my lord, on 6th February 2023 at page 329.
So you were asked to furnish a security.
Yes.
In the trial court.
Yes. Now, my lord,
For the amount of this much.
of much, yes, 9 crores and odd.
Uh,
Now, my lord, what the Supreme Court said was that, my lord, it should be, my lord, encashable security, not cash security. Now, my lord, we have furnished, my lord, by way of security, my lord, immovable properties which are accordingly to us completely unencumbered. Title deeds, my lord, there, my lord, not a shred of encumbrance on that. Now, my lord, we had said that. Now, my lord, when my learned friends, my lord, approach the court, when we, my lord, proceed for hearing of the Order 7 Rule 11 applications, my learned friend says that they have not complied with the order of Supreme Court. This is not sufficient compliance with the order of Supreme Court. You have not furnished encashable security. It should be cash security. Well, I don't have cash.
What does the Supreme Court say? Furnish security to the satisfaction of the trial court, so and so is concerned. The security is to be furnished.
Solvent security. Well, at paragraph 3, it says would be solvent security. Well, at solvent security means, well, it's security which is not really encumbered. Otherwise, it would have said cash security.
Solvent security which can be encashed.
Right. Now, my lord, today, if I furnish, my lord, for example, my lord, if I, my lord, furnish a mortgage deed, if I mortgage an immovable property, now, my lord, the mortgage can always be enforced. The property can be sold and encashed. But, my lord, if I don't have money presently, my lord, how do I furnish cash security? But, my lord, the Supreme Court, the division bench first, then the Supreme Court made it
But
very
where
clear.
is the money from the acquisition proceeding?
My lord, that, my lord, acquisition proceedings, the money was spent away. My lord, there are other business expenses that were incurred. Further, my lord, receivables have been asked not to be dealt with now. My lord, there is 9 crores of rupees that's lying with the court, with the Registrar General.
Here,
Yes.
that is from where?
My lord, that is, my lord, from a part of the compensation payable.
Why is
Which-
that here? Which
My
directed
lord,
to be?
there was a compensation, my lord, proceeding. My lord, there is a challenge before this court. Court directed payment of 50%. My lord, which came into the account, which has been used up. Directed to deposit the balance 50%, which is again about 9 crores and odd, with the registrar of the Supreme Court. It is lying there. But I don't have that money. So, my lord, I offered immovable property, which is unencumbered. Now, my lord, what the learned, my lord, what the learned trial court has done, if you lordship kindly sees, my lord, the order, I just need to show, my lord, just one part of the order, page 3 of the impugned order. Let's kindly see the last paragraph, starting with learned counsel for the defendant.
What was the division bench's direction? That
The division bench said, my lord, you furnish, my lord, security. Well, that's at page 23. Well, at second paragraph, with a view to hold the ring pending final adjudication, we permit come, my lord, that is, my lord, previous Lindsay, to retain and utilize the said amount upon furnishing security to the satisfaction of the learned trial court. In so far as the balance sum of 9 crores 5 is concerned, deposited in collection with the LA case with the Registrar General to release, not inclined to direct Registrar General to release the said amount at this stage. Well, that is already lying there as security. It's with the registrar. Well, that is, of course, that's already there. Plus, my lord, I am, my lord,
was this brought to the notice of the Honorable Apex Court that
Well,
this amount is lying?
I am not sure, my lord. My lord, we were not, my lord, before the Supreme Court. But, my lord, all that I'm saying is, my lord, here the Supreme, one thing is very clear. My lord, there are two separate parts. One is, my lord, the security to be furnished. One is Order 7 Rule 11. Division bench says,
See, Mr. Shah, but what I'm on is that once this 9 crores is secured somewhere, could it be the intention of the Supreme Court that a further 9 crores will be secured somewhere else?
it is possible, my lord, as your lordship has correctly pointed, it is possible that this was not drawn to the attention of the Supreme Court. But nonetheless, my lord, let us, my lord, proceed on the premise that, my lord, it was drawn to the attention of the Supreme Court in spite of that Supreme Court directed furnishing of, my lord, further security. What the Supreme Court says is furnish solvent security. It does not say furnish cash security.
Which can be encashed. Solvent security which can be
That's right.
encashed.
Now, my lord, we are looking at, my lord, hypothecated materials. We are looking at mortgages. These are the conventional modes, my lord, of securing payment. Now, my lord, all that I'm saying is, my lord, the learned, my lord, judge in the court below has my lord simply said this. It is not
Where is
clear to
that?
this court, my lord, page 3 of the impugned order.
Hmm.
My lord, kindly see, my lord, the last 2 lines at my lord, page 3. It is not clear to this court whether the court shall proceed with the hearing of the suit when admittedly none of the directions given by the honorable court have been complied with. The defendants are thus directed to move the honorable apex court and seek clarification as to whether trial court should proceed with the hearing of the suit without the defendants having complied with any of the directions. Now, my lord, the division bench, even while directing security, says, hear out the applications under Order 7 Rule 11. Supreme Court says, hear out all the other applications. But I don't want to see any reason for which, my lord,
Mr. Shah, that this Registrar General money that is secured with the Registrar General
that's right.
on the basis of justice, this order.
No. My lord, there is a, my lord, proceeding, my lord, where, my lord, for compensation, my lord, which is being contested by the state. My lord, that's the first appeal from the my lord, requisition, my lord, proceeding.
case.
Yes, LA case. My lord,
They filed the first appeal.
yes,
So they were asked to secure the money.
yes. So, my lord, that money is lying deposited there. My lord, 9 crores spent, my lord, that was spent away, my lord, for various business, my lord, purposes. So, my lord, we don't have that money, but my lord, the property that we are offering as securities, my lord, I understand not less than 30 crores. My lord, that can be valued by anyone that your lordship directs. But my lord, that is not the question. The question is, my lord, can, my lord, this, my lord, impede the hearing of the Order 7 Rule 11 application? My lord, the learned, my lord, court below has opined that we are not sure as to whether, my lord, we can proceed with the hearing of the suit when the order has not been complied with. Now, my lord, it is a matter of opinion as to whether, my lord, the order has been complied with or not, because we say we have complied with the order. But irrespective,
How much money did your client receive in hand?
about 9 crores. About 9 crores. And, my lord, another 9 crores is lying in deposit. And, my lord, I can also tell you, lordship, that, my lord, there are 2 arbitral awards that are, my lord, now awaited, where we will expect to receive, my lord, other substantial sums of money. Where, my lord, my learned friends sought to intervene and tried to say that you should not allow them to contest the arbitration proceeding. But, my lord, the arbitration proceedings are concluded. My lord, before Justice Bhaskar Bhattacharya, we are awaiting an award. And, my lord, we expect that, my lord, again, further sums of money will come in. So, my lord, once that comes in, my lord, there is no difficulty. But, my lord, the difficulty is elsewhere. Well, it's a question of, my lord, whether, my lord, today, the hearing of the suit, my lord, was ever directed to be, my lord, stopped or suspended, pending, my lord, the furnishing of the
You're
security.
saying it, the disposal of the or your prayer for disposal of the applications was not subject to payment or
That's right.
security.
That is the only
That is
thing.
what you are saying.
My lord, there are 2 parts.
There is no condition precedent to disposal
right.
of the applications. That
My lord,
is
there are
your-
2 very distinct and separate parts. One is the furnishing of security. I say, my lord, I have furnished the security. My lord, that is, my lord, again a challenge where the, my lord, learned court below has asked me to go and obtain clarification on the Supreme Court. My lord, what clarification do I get? The Supreme Court has said solvent security which can be encashed. Supreme Court has not said cash security. And my lord, the second part of it is, my lord, today, Order 7 Rule 11 applications, my lord, there is no direction of any court that one is subject to, my lord, the performance of the other. All that I want is, my lord, these applications we heard, they may be allowed, they may be dismissed, whatever. But, my lord, my learned friends will not allow me to proceed with the hearing of these applications. At every stage, my lord, I have been, my lord, interrupted, my lord, whenever I've tried to, my lord, take these applications ahead. And, my lord, now they say that you cannot proceed with it unless you furnish cash security. I don't have money. So, my lord, the suits will never proceed.
One stage it was completely heard.
When did you receive that 9 crore?
My lord, 9 crores was received, my lord. Well, May 2021, my lord, my Mr. Kakrani informs me. It was in May 2021. 2021.
And this division bench order arises out of what? What was the order of the
My lord, they
civil
were,
court?
my lord, orders, my lord, again, the learned, my lord, that's it, my lord.
Item 26, page 40.
My lord, if your lordship kindly takes up, my lord, CO 1833, that is, my lord, at page, my lord, 40 of the CO
Can you
118.
just read that ordering portion?
Yes, my lord, I'll read it. My lord, their petition has been dismissed, but, my lord,
What petition?
my lord, my learned friends filed for injunction restraining me from operating the bank account. Well, it says, I just read the, my lord, last portion. Having gone through all the pros and cons of this case, it appears that the entire proceeding initiated by the plaintiff, that's my learned friend's clients, is a deceitful action on the part of the plaintiff, and the same director who has taken part in the conveyance and agreement as well as power of attorney came before this court for the relief which is not entitled, and this case is having no legs to stand upon. It is a futile attempt by the plaintiff, and the injunction application must end in dismissal. Hence, as an interim measure, to preserve the amount deposited in the bank, it is ordered that neither party is allowed to operate the bank account in any manner whatsoever till the disposal of the case, as well as title suit number 314 of 2021.
So this was challenged and
Malad, we said that, Malad, you have,
allowed to operate the bank account by Justice.
yes, yes, Malad, after, that's right. So, Malad, the learned Malad, Judge Malad comes to the conclusion that deceitful application, but put this money as, keep this money as security. But Malad, all that I'm praying is, Malad,
His part.
Yes.
But you can't also operate.
no, that's right. But now, Malad, I'm allowed to operate subject to furnishing security, which the Supreme Court now says,
There's
Sorry.
9 crores worth of security which can be encashed, which you say is not cashed, it can be encashed even if it is property.
and Malad,
How
I am
many
offering
companies
Malad
offer?
security worth 30 crores. But Malad, my Malad question is, Malad, that is one party. Whether Malad, this is appropriate security, adequate security, it's one part. But Malad, how can Malad, the applications not be heard? What Malad stands in the way of the hearing of the suit? Malad, learned Malad court bill has from.
Look at this in so far as balance of 9 crores is concerned, the same not withdrawn. Where what does this mean?
Malad, when Malad, this is Malad,
Paragraph 4.
Malad, there is
Supreme Court order.
Malad, balance Malad,
Paragraph 4 of the Supreme Court's order.
Malad, so far as
this balance which is lying.
Malad, oh, এটা পরিষ্কার করে বলে নেই কিন্তু।
This is creating a problem. The security is to be furnished. All right, let us say respondent would furnish security to the satisfaction of the trial court of rupees so and so. This is understood.
This is, yeah, this is Malad,
That
this
means
is,
the balance amount which is with the registrar general.
that is right, that is
So
right.
even if that state's proceeding is first appeal
It
is
comes to my account, I cannot
you
operate.
cannot withdraw it.
That's it.
But it's subject to the suit.
So probably the Honorable Apex Court took care of the fact that some amount is secured with
Yes.
the learned Registrar General, and for the rest you secure it before the trial court,
And this is only for the instant.
solvent security.
And Malad, today our claim was 24 crores. The state says it should be 18 crores, 9 crores paid, 9 crores deposit.
Oh.
24, 27, whatever. Take it.
And what was directed by the LA case?
LA case, 27 crores.
Oh, so they said admitted is 18. So that admitted part is kept,
Yes.
part of the admitted.
Part paid, part kept.
So I think this 4 means that what has been deposited in
Yes,
our.
yes, yes. That Malad, previous sum was
If any
received on
amount is
23rd
deposited in
June.
the bank accounts in SSO which is subject to matter of suit, the amount would not be withdrawn by any party without permission of the court. The trial court stated disclosing the compensation. As
Each says would be decided in accordance. 7 and 8 charges. All for the proceedings.
Said affidavit will be registered. The
Paragraph 7 and 8 of the Supreme Court order
6
clearly
is
says.
also clear that
Yes.
you will indemnify them if they have to pay.
Yes.
anything.
All these affidavits we have filed.
We further clarify that the observations made in the imperial order would be taken only for the purpose of disposal of the appeal and would not be treated as binding. Dispose of the appeal means this appeal.
Yes, madam. The appeal before
Still
the.
pending.
Yes.
No.
No, dispose of.
Oh, for the purpose of disposal of the appeal means the appeal
Appeal
before
before
the
the Supreme
Honorable
Court, yes.
and shall not be treated as binding when the trial court would determine the rights and pleas placed before this court. In accordance with law and upon evidence, we also given other proceedings with the parties pending before the trial court and other proceedings will be decided in accordance with law. Will be decided in accordance with law.
Yes.
So proceedings can continue. The trial.
Yes.
Well, I am only aggrieved by the portion that's when the land court bill has held that we cannot proceed with the suit. I'm not sure whether we can proceed with the suit till you comply with the order and has formed the opinion that this is not adequate compliance. I say it is adequate compliance.
Yes.
But everything has not been completely told before your lordship, my lord. The first suit was filed by them. The suit was for the account, bank account that was there in the name of Punalur Paper Mills, that is my client, should not be closed. Court granted an ad interim order of injunction. The second suit was filed by my client. In the second suit, we had prayed that they should not be permitted to make bank transactions without our consent because the management had changed. They admitted that. But in both the matters, injunctions were ordered. They came up before the High Court. High Court passed an order. But thereafter, the injunction matter was disposed of together. And the order was that my client is not correct, and accordingly, their injunction application was allowed. But we came up before the Honorable High Court. Lordship has seen the order passed by Justice Showman Shin. But there is categorical observation that apart from the amount that they have already got in their hands, no other amount should be taken. 9 crore and odd, that has already gone to their hands. But that has gone through our account. But it was in a designated bank, that is IndusInd Bank, whom my learned friend is representing. Through that, this compensation amount has gone to their hands. But during the course of proceedings before the trial court, there were orders. You should not take away the money which has come in the bank account. That was ignored. Orders were passed. You should refund the entire amount. But thereafter, again, another revision in which there was an order. Very well. Keep the account for the time being subject to the decision of the injunction matter. In the injunction matter, it was held that they can retain the amount, they are retaining the amount. But thereafter, in the division bench before this court, it was the direction you cannot take any further amounts. But challenging this order, my clients went up to the Honorable Supreme Court. But the Supreme Court order has several parts.
Yes.
Marat, this kindly comes to the order impugned.
Yes.
The second page of the order. But this is the observation as pointed out by us that the Supreme Court orders.
Where is that?
Marat, the second page of the impugned order.
It starts from where?
But challenging the second paragraph.
Challenge.
Yes. May I place it, Muller?
Yes, please.
Challenging the judgment passed by the Honorable Supreme Court of, judgment passed by the High Court at Calcutta, plaintiffs preferred civil appeal numbers such and such, and after hearing the said civil appeals, the Honorable Supreme Court of India, vide order dated 26 September 2022, kindly marks this date, disposed of the said civil appeals by giving the following directions. The respondents being the Calm Industries Private Limited and others would furnish security to the satisfaction of the trial court, Malat satisfaction of the trial court for rupees 9 crores and odd. And the same should be furnished within a period of 2 weeks from date. Malat from, this is September 2022, 2 weeks. Now the second part. The security to be furnished to the satisfaction of the trial court would be solvent security, which can be encashed and enforced in case of default. But this is very important. These are the wordings of the Supreme Court order. Malad, next. Insofar as the balance amount of rupees 9 crores and odd is concerned, the said amount would not be withdrawn. If any further amount is deposited in the bank account in IndusInd Bank Limited, which is the subject matter of the suit, the amount would not be withdrawn by any party without the permission of the court. Next, the respondents Calm Industries Limited and others would disclose the compensation amount received from the land acquisition authorities and shall file affidavit before the learned trial court. Another direction. If any tax liability arises to the plaintiff, the respondent defendant number 3 would indemnify the appellant plaintiff. The trial court would determine the rights and please the yes, my lord, raised and the pleas raised by the parties before this court in accordance with law and based upon the evidence available. The other proceedings between the parties pending before the trial court or any other proceedings would be decided in accordance with law. My lord, all these heads, these have not been complied by them. First thing, my lord, they did not furnish the security within 2 weeks. The applications that were filed before the trial court, they have not annexed it. I can show that to your lordship, my lord. Here, arekta kore copy dao. My lord, some person who has filed the affidavit is nobody of the company. These are the 2 affidavits that were filed. Copies were sent to us through emails. Well, we have got it. We filed objections to it. My lord would kindly hear me for a moment. My lord, the second direction was, it has to be to the satisfaction of the trial court. The trial court was not satisfied with the security. Why? Because the Supreme Court order says it should be solvent and encashable security. They are showing a property deed that is in respect of the entire property which is under acquisition. But they say the portion that they want to mortgage before the court, that is not encumbered. But who will look into this? But this has not been clarified in any of the applications that were given before the trial court or in the affidavits given. But they want to evade this. It has been the submission.
I'll just interrupt. There's a full bungalow in Paliganj. I'll give that bungalow.
Kindly permits me to complete, my lord.
No flat.
That is not required. It's a solvent encashable security that is required. But just now, Mr. Shaha, my learned senior has said they had got 9 crore rupees rightly, but they have, that has been to their expenses. They have got another 23 to 27 crores in the arbitration proceedings before Justice Bhaskar Bhattacharya. That is why the Honorable Supreme Court directed, disclose what you have got in the trial court. But that is the 4th direction that has been recorded by the learned trial court. Kindly see page 2. Item number 5. That is in the Supreme Court's order.
That is for land acquisition.
Yes, they have not disclosed it. In the affidavits that they have given, they have not disclosed it. My learned senior said that we have got only 9 crore rupees, but that is not true. What they did, apart from this IndusInd Bank account, they have opened another account in our names. Our director's signature have been taken, and those are forged signatures. On the basis of that, another account has been opened in IDBI First Bank. There, everything has been taken. The compensation amounts as per the agreements and the understanding between the parties were to go to IndusInd Bank. Unfortunately, that did not happen. They took it to IDBI First Bank.
But compensation is 9 crores.
No. Apart from that, in the arbitration proceedings, it was awarded around 23 crores and odd. They have got that money. But in accordance with
What
this,
is the sense? The award has been enforced,
my
executed.
lord, a portion
May I
of
just
the
clarify?
award.
My lord, the Supreme Court has directed, my lord, this is the language.
Solvent and encashable.
Disclose compensation received from land acquisition authority.
Yes, that I've seen.
Now, my lord, this is, my lord, the land acquisition, my lord, matter. Apart from that, my lord, there are certain PSUs, my lord, which had also, my lord, requisition properties. In that arbitration is going. There was an interim award, my lord, that was made in the arbitration. That interim award money has come in, but these are not from land acquisition proceedings.
No, but that money is with you then.
Yes.
Well, so far as that money is
That is there. The IDBI statement,
Give a bank guarantee of that amount.
absolutely, my
9
lord.
crore. Matter ends, encashable solvent.
Yes. That was the desire of the Supreme Court.
Mr. Shaha, you take instruction and come and tell me. That should be the easiest way out.
Well, your lordship, my lord, is looking at a bank guarantee. My lord,
Yes,
bank guarantee guaranteeing what, my lord, I'm wondering.
that amount from the money you
No,
received
my
in
lord,
interim award.
I have to guarantee, my lord, the performance of some obligation. My lord, bank guarantee will be encashed when? My lord, because, my lord, when your lordship directs furnishing a bank guarantee, for example, if it's a performance bank guarantee, my lord, then, my lord, in default of performance, that is encashed. We know of mobilization advance bank guarantees. My lord, if you fail to refund the money, that will be encashed. Now, my lord, here, my lord, today, I've already given an indemnity. My lord, that is an affidavit that I've filed. Now, my lord, I can, if I give a bank guarantee, it will be in aid of what, my lord, I'm wondering. My lord, today, if there's a direction to make payment to my learned friends, of course. But my lord, there is no such direction. There is even no demand on them till date. And my lord, I have said that, my lord, I will take care of the entire obligation. But my lord, bank guarantee, my lord, to secure what? It's a security. Bank guarantee is a security. My lord, my learned friends are, my lord, are apprehensive of, my lord, only one thing. That, my lord, if there's a tax burden on them, my lord,
No,
that
no.
should not come to them.
But there may be a result in positive in favor of my client. My client succeeds in the suit.
You are, no, you are not accepting the transfer.
My lord, I am accepting the transfer. Kindly appreciates one thing, my lord. But the acquisition took place.
No, you have.
But only one aspect.
Yes.
The acquisition took place at a time when I was the owner of the property. First thing. But the property was transferred. But the amounts that would come, that was never transferred. But a separate deed is required for that. But I will have to prove that before the learned trial court. That is not my subject. My lord, before my lords. My lord.
Transfer is with everything.
My lord, I accept the transfer. Transfer was made. But the acquisition. But
Now your client became
wiser later.
No,
my lord, the acquisition, my clients, my lord, his director was also my director.
this money that you got as an interim award.
Yes.
How has that been dealt with by you? Have you used it in the business?
I will have to, my lord, take instructions. I don't know. My lord, that was not the subject of land acquisition, my lord.
Do not.
Yes.
You on that.
I have to take it.
But
I don't know.
A solvent, apart from like they are saying that house which you have mortgaged is theirs. Is
Let the registrar, my lord, decide whether, my lord, there's any encumbrance. I shall give all title documents. If my learned friends are not satisfied with 2 flats, well, I can give an entire bungalow.
Satisfaction, it is the satisfaction of the courts. Yes.
So now
No, my lord, the
my
trial.
satisfaction.
Yes. Now, my lord, I can, my lord, the question is, my learned friend has to be secured. For what? Secured, my lord, according to the division bench, according to Supreme Court, for, my lord, the tax liability that can come upon them. My lord, that immediately, my lord, has been assessed even in the absence of any demand at about 9 crores of rupees. Now, my lord, today, I have, my lord, already, your lordship has said that, my lord, there is already an amount lying with the registrar. My lord, there's already a direction that I will not take it away. Now, my lord, I am, my lord, prepared to offer, my lord, solvency. What more do they want? My lord, the idea is not to vex me. The idea is not to vex me, my lord. I am prepared to offer security. My lord, 9 crores of rupees
See,
lying.
one thing, your tax liability, according to you, is around 9 crores. That money is already there.
No, apart from that.
If they lose the appeal,
apart from that.
money will go to
That's right.
That's the admitted case.
That's right.
So that money will be subject to, can be given to you or towards your tax liability.
Lordship.
Right.
My lord, every amount that
So
is
now-
coming, it is in my name. Punalur Paper Mills.
Maybe
My lord, which they are utilizing. They are now saying the money that had come, that has now been utilized in my business.
Place, they didn't pay you anything?
But I tell your lordship, my lord,
it was a valuable
but
consideration.
that will be decided in the suit.
4.5 crores.
Yes, so.
But I have,
If
if my lords,
Well, I can satisfy your lordship's registrar general. I can, my lord, give all the title documents. I can give undertakings that, my lord, there is no encumbrance.
But the Supreme Court decides something else.
Supreme Court desired that there should be a security
That is solvent.
which is solvent and encashable.
Yes.
If the Supreme Court desired that it should be in the nature of a cash deposit? Supreme Court did not say.
It should be a bank guarantee, my lord. Otherwise, these words should not have been used. Now, I can show you, lordship, what the word solvent means, what encashable means. An immovable property is not an encashable security. I cannot encash it at any time. But why the other side did not disclose
Supreme Court
the
could have
amount
said
of
bank guarantee,
compensation
could
they
have
have
said
received?
cash security, could have said cash deposit. It has not said it.
Encashable, immovable property being encashable
It is
not
impossible.
the same term is not used like that.
Look,
is it?
First, my lord, first thing is, my lord, today the extent of, my lord, assumed liability, although
A mortgage by deposit of title deed, which you are actually
yes,
doing.
yes. Now, my lord,
That
today,
should be taken as an
my lord,
encashable.
kindly take that along with, my lord, the 9 crores that is lying with the registrar.
should
There's
have-
already a direction. I will not.
Observe that. So it's as if the 9 crores and the 9 crores, so a total 18, whatever you have got, you have to secure that.
Well, I understand that, my lord. Let us, my lord, proceed on that understanding. 9 crores plus security. That's why I'm not saying that accept that 9 crores. I'm saying that accept further security. Now, my lord, encashable security, my lord, my learned friend is going on a dictionary meaning. Are we, my lord, really arguing on, my lord, what is the meaning of encashable in the context of a statute? Are we saying what is the meaning of solvent in the context of statute? It is, my lord, the general understanding of solvency. My lord, the Supreme Court is, my lord, very conscious of, my lord, what it seeks to do. Supreme Court could have said bank guarantee, did not. Could have said cash deposit, did not. Could have said cash security, did not.
But also did not say
But-
immovable property.
No, my lord, that is not the thing. My lord, so, my lord, the division bank said 9 crores. Supreme Court says very well that 9 crores is there, plus you give other encashable solvent
He has
security.
got the money. He
No, my
has got around
it is-
32 crores and odd, if not
My
more.
lord, today,
And
my
now
lord,
he
is
says,
this
"I
something
cannot
that I'm not
secure it."
entitled to? Now, my lord, my learned friend's interest is only to the extent of what he says is tax liability. Let him show, let him say what is his
I
tax
will prove
liability.
that in the trial court, in the evidence of the suit.
My lord, the trial
That
court, my lord,
states-
tax liability, whether, my lord, the suit survives, does not survive. I've already said that, my lord, this is my liability. My lord, that is, my lord, what I have to, my lord, accept, and I have accepted. Whatever is the tax liability will be my liability. But, my lord, more than that, they can't claim anything. My lord,
No, but Supreme Court went on to say solvent part, yes. If the house is unencumbered, it can be a solvent security. But why encashable?
well, encashable, my lord, today, my lord, encashable, my lord, today, my lord, even a check, my lord, has to be presented for encash.
Yes, check, fixed deposit.
My lord, today, my lord, so far as that is concerned, my lord, today, my lord, on that aspect, my lord, may I just respectfully submit this, my lord, this is one aspect of the matter. What should be the security? My lord, that is one aspect. The second aspect of the matter, whether the suit should, my lord, proceed or not. My lord, these are, my lord, respectfully independent of each other. Now, my lord, your lordship will, my lord, ask me to come back with instructions on that. I will. But, my lord, let the suit proceed. Why the suit will not proceed? My lord, that the Supreme Court never interdicted. Now, my lord, so far as security is concerned, my lord, today, my lord, your lordship, my lord, is looking at the word solvent and looking at the word encashable. Now, my lord, these two, my lord, perhaps are a little bit at cross purposes with each other. Now, my lord, today, my lord, in view of what is, my lord, we had preferred an appeal. An appeal was preferred against the judgment of the division bench. The division bench confined it to 9 crores.
9 crores, which is with the registrar general.
That's right. Now, my lord, the Supreme Court has said additional, my lord, solvent security. My lord, I would, my lord, request your lordship to, my lord, read it, my lord, in conjunction with the division bench order, because, my lord, the Supreme Court, my lord, said that yes, keep that and give some solvent and cashable security, noticing that fact that this money is already lying there. My lord, today, my lord, I cannot, my lord, the object cannot be to vex me. Now, my lord, the courts have held, my lord, without any shred of doubt that, my lord, there's a valid transfer in my favor. So, my lord, I'm entitled not only to the property, but all, my lord, accretions from the property, including from, my lord, compensation, my lord, receivables. Now, my lord,
All right, you take instructions. I have to rise.
yes, my lord.
When do you want me to keep it?
My lord, we can come back tomorrow also. Or, my lord,
Afternoon, actually, I have.
no, my lord, we can come back, my lord, whenever your lordship wants. Monday, Tuesday, my lord, whenever.
Monday,
সোমবার কত তারিখ?
let this matter appear on. Sombar is 10th.
ফিক্স করে দাও না, 2 PM 4 PM থেকে সুবিধা হয়, বেশিক্ষণ লাগে না।
So, করি থাকবে। পাঠার তো।
Enough. Top fixed.
My lord,
Under the heading top fixed.
yes, I'm grateful.
But for further consideration, if my lordship.
You want to show something?
No, for further consideration, lordship may kindly record.
Ah, for further consideration.
Lordship can understand. I'm grateful, Milord.
With the double.
But all the three
Grateful.
matters.
My all three matters.
All the
তিনটেই একসঙ্গে order করে দাও। As in view of the similarity in the facts and law involved, the revisional applications are taken up. Yes,
আমার solicitor দাঁড়িয়েছে, আমার
yes, yes. Pass over afterwards. Let me take the expeditious disposal.
Second up.
Item 30, I am for the petitioner, madam.
Yes,
I am praying for a direction upon the learned court of appeal below to dispose of the appeal being title appeal number.
anything pending? Any application pending?
No, madam.
Take down. The petitioner is the
The appellant.
appellant, plaintiff appellant
Yes, madam.
in title appeal number 04 of 2021, which is pending before the learned civil judge, senior division, Kandi, Murshidabad. The petitioner submits that the appeal has been pending since long
Long ago, madam.
and the defendants have, summons have been issued.
Tomorrow only matter is appearing for the SR and AD.
And several dates have been fixed for SR and AD.
And next date is the 10th of this month.
Unless service is complete, how can I dispose or direct for disposal? Having considered that the appeal is pending for almost 2 years and service is not complete, this court directs the lower appellate court to take expeditious steps and ensure that proper steps are taken for service upon the defendants. You ask for substitute service.
My lord.
Defendants, respondents in the suit. The LCR shall be called for and should be sent immediately. Should be called for immediately, LCR. And the learned court, lower appellate court shall also ensure that the LCR is received within 10 days from date of communication of this order. Upon completion of the above exercise, title appeal number 04 of 2021 should be disposed of in the next 6 months. Yes, all right. This court has not very critical.
My lord, I am for the petitioner. My lord, in this matter, I am praying for the expeditious hearing of the contempt application of the injunction petition, my lord. That is order 39, rule 2A petition, my lord. Injunction was passed, status quo has been given, my lord, but in spite of that,
the petitioner is the plaintiff.
Yes, my lord.
In title suit number 47 of 2020, which is pending before the learned civil judge, senior division, first court, Tomlu, Purbo Medinipur. The petitioner submits that in violation of an order of injunction, the defendants had that the defendants had acted in violation of the order of injunction, and accordingly, an application under Order 39, Rule 2A of the Code of Civil Procedure was filed, which was registered as James case number 17 of 2020. Petitioner prays for expeditious disposal of James case number 17 of 2020, and thereafter expeditious disposal of the suit.
My lord,
Yes.
Time may be fixed, my lord.
তো তারপরে যা দিয়ে তারপরে হচ্ছে জেমিস কেস, they have filed their objection.
My lord, they are appearing in the
The James case, have they filed their
yes,
objection?
they are appearing, my lord. I don't know what objection
James
has
case
been-
to dispose of.
Yes, my lord.
When
they
is the
filed.
next date?
Next date.
Months from the next date fixed. The main injunction application has been disposed of. Or
Injunction
additionally,
application has been disposed of. Order of status quo was passed, my lord. Thereafter,
I have understood. Is it at the ad interim or the final?
ad interim, ex parte order was passed, my lord.
So that you wanted order 39 rule 2A.
Yes, my lord. I filed the order because they have violated the order of status quo, my lord.
Ad interim order, right?
Yes, ad
তাহলে
interim.
ওখানটা ad interim order of status quo লিখুন। কোথায় আছে? এই violation of the order of injunction বলেছি না? Ad interim order of injunction in the nature of state of. I know, ad interim injunction. So say those things properly. Injunction in the nature of status quo. The petitioner filed an application under Order 39 Rule 2A of the Code of Civil Procedure challenging such violation, which was registered as JB's case number 17 of 2020. The JB's case number within 2 months from the next date fixed. Thereafter, the application for injunction shall be disposed of expeditiously. Yes.
My lord, time may be
2 months
grateful, my lord.
from the next date fixed. Yes.
My lord, I am appearing on the petitioner, my lord, petitioner praying for petitioner husband, my lord, my lord, praying for expeditious, my lord, parentary hearing, my lord, which was fixed on 2000.
What?
My lord, mat suit, man. My lord, 2000.
Petitioner is the wife in matrimonial suit number 5.
Petitioner husband, my lord.
Oh, petitioner is, you're paying in.
Yes, my lord, this is the order. Yes, my lord, this is the order, my lord. Kindly, my lord, my lord, 28 September, my lord, parenthood, before my lord.
Take down, the petition is the husband in matrimonial suit number 578 of 2019, which is pending before the learned. Additional district judge, fast track second court at Kontai, district Purbo Medinipur. The petitioner is aggrieved because the matrimonial suit is not progressing. Why is it not progressing?
My lord, each and every occasion taking the time, my lord.
Submitted that the wife has been repeatedly asking for praying for adjournments, and the learned court below is allowing such adjournment. Next.
Next date
That the suit has been fixed for peremptory
18 September 2023, my lord.
Evidence?
My lord, parentary hearing, my lord. Fixed for PH, my lord.
Issues were framed.
Yes, my lord, everything complete, my lord, only time.
Where is issue frame? কখন যে PH, আগেও PH, পরেও PH এর কোনো ঠিক নেই। Where are the issues framed? What are the evidence?
My lord.
This is all Jamie's case. You have given order sheet of Jamie's case. What about the mat suit? Disclosure versus liabilities. Final order was passed for maintenance pendentality.
My lord.
Huh?
No.
I'm ready. Oh, you serve. There is another suit which is pending restitution of conjugal rights. The wife has asked for analogous hearing.
My lord, this is this was considered this was considered kindly, my lord, order.
Considered and what? What order was passed?
My lord, this the rejected the prayer.
Where is that?
This is the my lord. Malo order sheet, malo. Copy the order.
It was not rejected for analogous hearing.
मतलब कल मालूम ऑर्डर मालूम कि 13 के November 2022 मालूम
30th November.
हाँ November
Where is the court saying dismissing the application?
मालूम
Court said that
the respondent के has filed के one के petition prayer के for time के game
what
content
time? For
Mal-
time inter alia that another mat suit is pending.
pending the
Court said that time will come ready.
yes मालूम
See of mat suit 9 of under the Hindu Marriage Act cannot be a bar. না কি বললাম?
not granted
Issues were not framed.
no मालूम
Evidence has not started.
no मालूम parental PH मालूम
Where is the order of maintenance?
मालूम कहीं नहीं मालूम
It appears that the suit was the respondent had been asked in the suit had been asked to show cause as to why the suit should not be disposed of ex parte for non-appearance of the respondent. Affidavit of assets were directed to be sold. The JB's case is pending.
yes ma'am
Maintenance case is pending.
yes ma'am
Then how can I direct the disposal of the suit?
no मालूम hearing मालूम the parental hearing मालूम not take
Unless the maintenance application is disposed of, how can the suit be disposed of?
the maintenance मैं disposed मालूम कल मालूम
Disposed of.
Plaintiff is the petitioner before Malad, but seeking expeditious disposal of this suit pending before the Second Court of Civil Judge Junior Division at Alipur Malad.
You are the plaintiff.
I was the plaintiff
Plaintiff number 3 in title suit number 132 of 2030. Prays for expeditious disposal of the said suit which is pending before the learned Civil Judge Junior Division Second Court at Alipur. Any application pending?
Connected applications order under Order 7 Rule 11D
Submits that an application under Order 7 Rule 11D
filed by the defendants and another application under Section 151 filed by the plaintiffs.
an application under Section 151 of the Code of Civil Procedure are pending before the learned court below.
Next date is fixed on 7th of July.
Submitted that I can't do it. I mean, what will I do of 7th of July? The learned court be directed to dispose of the title suit along with the pending applications.
There was an earlier order of this honorable court also for
It is also submitted that a learned coordinate bench had directed expeditious disposal of the suit and the applications, but the same are still pending. তারপরে যা করে ওই করে অ্যাপ্লিকেশন গুলো হবে হচ্ছে within 2 months from the next date fixed আর suit তারপরে following year. Next.
report your lordship, I am for the petitioner. Lordship, it is a suit for partition. The preliminary decree was passed and shares of the respective parties were declared. Your lordship, one of the defendant co-share have sold his share to the predecessor of the petitioner, your lordship. And your lordship, thereafter I have inducted as a party, and thereafter your lordship, I have filed an application for the rectification of the preliminary decree, your lordship, because of change in circumstance, your lordship. That is in 2017, and that is kept pending. And your lordship, there are also other two applications, one for removing the padlock from a grill gate. That is
How many applications are pending?
3 applications, your lordship.
You have filed all the applications?
No, your lordship, one is one application dated July 19,
Petitioner please for
2017.
expeditious disposal of title suit number
71 of
71 or 1959,
Yes, your lordship.
pending before the learned civil judge, senior division, 3rd court at Alipur. This is a what suit? Partition suit?
Partition suit, your lordship.
The suit is for partition. It is submitted that an application for modification, that 3 applications are pending, namely an application
Application
for
dated, lordship.
modification of the preliminary decree, an application for under section 151 of the code of, and 2 applications under section 151 of the Code of Civil Procedure. Considering the age of the suit, this court is of the view that the prayer of the petitioner is completely justified.
Lordship, next date of hearing is on July 24.
ওটা যা থাকে দিয়ে দেবে।
For your lordship,
অপোজিট পার্টি তুমি মাঝখানে কপি পেস্ট করে পার্টি লিখছো, তারপরে দেখা যাচ্ছে পার্টিজও আছে। সার্ভিস আপন দ্য অপোজিট পার্টি লিখছো তো পার্টিজ হবে, যেখানে যেখানে পার্টি হবে পার্টি ওই জায়গাটা চেঞ্জ করতে হবে।
lordship, next date of hearing is on July 24th for hearing of those 3 applications. If your lordship can direct that application to be
Yes,
disposed of on
it
that date.
appears from the order sheet that all the 3 applications have been posted for hearing on July 24, 2023. তারপরে যা আছে সব করে দিয়ে within a month from the next date fixed.
Lordship, expeditious hearing of the suit itself.
After conclusion of the disposal of the applications, title suit number so and so shall be disposed of. Preliminary decree has been passed. No appeal.
No appeal, your
You all
lordship.
wanted only modification.
Yes, your lordship.
And what about partition commissioner?
Partition commission, actually, lordship, there is a application pending for early commission, your lordship. That is also
আচ্ছা
pending.
ওখানে করে দাও 6 months
Great.
from disposal positively without granting any adjournment. Yes, next.
It's my application, madam.
Yes.
Yeah, madam, I'm the petitioner defendant, my lord. The suit is pending from 2003. The declaratory suit, my lord, 2003.
Applications
No
pending.
application pending, 2003 suit. Evidence of the plaintiff witness complete in 2018 only. Just to get the lacuna of the depose their commissioner appointment, that was appointed in December. No, the commission is
Wait,
not filing the
Petitioner is the
defendant, my lord.
Title suit number 281 of 2003, which is pending before the learned civil judge. Junior
Third
Division,
Division.
First Court at Alipur. The petitioner prays for expeditious disposal of the suit. It is submitted that evidence of
Plaintiff witness
PW was completed
on 2018.
2018. Thereafter,
They made an application for appointment of commissioner.
application for commission was filed, which was
Allowed
allowed
on December last year.
December 2022. Next paragraph. Considering the age of the suit, this court finds that the prayer for expeditious disposal is innocuous, is justified. তারপরে যেগুলো থাকে 6 months
Grateful, lordship.
from the next date.
Grateful.
Serve them copies.
I will. Grateful.
Well, I am for the petitioner, Lord. The defendant is the petitioner before lordship is a partition suit pending since 2014, Lord. No application pending.
Petitioners are the defendants, some of the defendants or all.
Some of the witnesses.
Some of the defendants in partition suit number 335 of 2014, which is pending before the learned civil judge, senior division, Berhampur, Murshidabad. The petitioner submits that no applications are pending and the suit may be disposed of expeditiously. Echono SR
My lord.
or for all.
No, for some.
It appears that the suit is the service of summons upon some of the defendants are not complete. কার জন্য স্যার? Fresh requisites were directed to be deposited
5, 6, 7, 9.
receipt of defendant numbers 5, 6, 7, and 9.
My lord.
Considering the age of the suit and the long pendency thereof, this court is of the no application is pending. Bolechi. This court directs the learned civil judge, senior division, Behrampur, Murshidabad, to ensure proper service upon the defendant number so and so to so and so immediately. Now, within a short period. And if such service is not possible, recourse be taken to the other provisions of the Code of Civil Procedure to ensure that these defendants are put on notice. ঠিক আছে? The upon completion, thereafter the suit shall proceed in accordance with law, and amended plaint was filed. You filed a statement according to law and disposed of within the next 6 months. Without granting unnecessary adjournments to the parties, it appears also that the suit is proceeding ex parte against some of the defendants. Now, against the defendant numbers 8, 10 to 15, and 22 to 24. About 5 to 24.
8, 10 to 15, 20 to 24. My lord.
Now, what is this order? Summons upon defendant numbers 5 to 24. DA is directed to issue.
No, that was issued thereafter, my lord, that some of them returned with the endorsement unserved. 5, 7, 5, 6, 7, 9.
So finally, ex parte against 8, 10 to 15, and 22 to 24.
Mal.
That's the final decision.
My lord, my lord.
Yes. Next.
37, my lord, I'm petitioner people, plaintiffs are the petitioners before lordship, my lord. Suit for declaration. And my lord, I find, my lord, an application. No applications are pending, my lord.
You are the
Plaintiff.
The plaintiffs entitled suit number 31 of 2015, pray for expeditious disposal. Now, which is entitled to pray for expeditious of the said disposal of the said suit. The suit is pending before the learned civil judge, Junior Division, First Court, Behrampur, Murshidabad. It is submitted that the suit is for partition.
No, my lord, declaration.
For declaration and injunction.
My lord.
No applications are pending.
Pending.
The what stage?
Interim order being extended since 15.
That is, injunction is pending.
Injunction is also pending, my lord.
It is submitted that the application for injunction is pending, final disposal, and that interim order has been extended from time to time. Injunction, other applications?
No other applications are there.
The injunction application, they have filed their objection.
No, but from the record I filed no.
That the injunction application shall be disposed of within 3 months from the next date fixed upon granting one last opportunity to the contesting defendants to file their written objection.
Well.
After disposal of the injunction application, the suit shall continue expeditiously and be disposed of within a year therefrom.
Without granting any adjournment.
Now, it is made clear that unnecessary adjournment should not be given to any of the parties.
Great.
Yes, next.
Lordship, I'm appearing for the petitioner. I'm the defendant in the court below. Lordship, the plaintiffs have vexatiously filed a title suit against me. I have filed a petition under Order 7, Rule 11. They're constantly taking adjournments and seeing their conduct. The lower court imposed a cost of rupees 300 on the last date.
For the
Defendant, Your Lordship.
defendant in title suit number 261 of 2022, which is pending before the learned civil judge, Junior Division, First Court at Barwipur, seeks expeditious disposal of the said suit. No applications pending.
Lordship, Order 7, Rule 11 application. Lordship.
That an application under Order 7, Rule 11 of the Code of Civil Procedure is pending. What they took adjournment in that application.
Lordship.
The further allegation is that the plaintiffs have been taken. How many plaintiffs are there?
One, Your Lordship.
The plaintiff has been taken. You are which defendant?
Defendant 1, Your Lordship.
Petitioner is the defendant number 1. ওখানটাই লিখবেন যেখানটা
Your Lordship, cost was also imposed on the plaintiff.
submitted that the plaintiff had taken multiple adjournments and on the last occasion cost was also imposed.
Lordship.
তারপরে ও যা আছে তাই তারপরে the application disposed of within 2 months. তারপরে from the next date fixed suit a year thereafter.
Grateful, Your Lordship. Great.
My lord, I am for the petitioner. The plaintiffs are the petitioner before Lordship, my lord, in a suit for declaration, my lord, and pending since 2015. Here I found, my lord, Order 22 Rule 4 application is still pending. Lord, that can be disposed of fast.
Abatement.
My lord, Order 22 Rule 4 CPC is still pending. Kindly have a look at order dated, order number 13, dated 14/12/21.
Plaintiff, the petitioner. The plaintiffs are the petitioners, they pray for expeditious disposal of Miss Case number 11 of 2016, which is pending before the learned civil judge, Junior Division. Learned District Judge Murshidabad
Barampur.
At Barampur.
But from the order sheet, I find Civil Judge Senior Division Berampur. But it must be Civil Judge Senior Berampur.
Yes.
It must be, Lord.
Civil Miss Case 11 of 2016.
Civil Judge Senior Division First Court Berampur.
Civil Judge Senior Division First Court at Berampur. It is submitted that steps, you can't take steps only, then what can be done? With these unready suits, how can I direct? Tell me, service is only not complete.
Lord, the applications are still pending, Lord. 24, 22.
So they are not, they have a right to contest the applications also.
If they do not choose to appear, Lord, then
So the service return will come. Steps do not indicate that the return hasn't come.
kindly direct for face steps, my lord, so that that can be disposed. Kindly direct for face steps, my lord.
And the court has directed. This court finds that service in respect of the Miss Case as also the title suit are not, Miss Case service is complete.
No.
Are not complete. Hence, the revisional application is disposed of directing the learned so and so pending. You are reading District Judge Murshidabad.
But District Judge, kindly have a look at the order sheets. District Judge Murshidabad in charge. In all the order sheets, my lord. But in one of the order sheets, it has been written Civil Judge Senior Division First Court.
Civil Judge Senior Division Berampur.
First Court.
First Court at Berampur to dispose of the pending application to ensure that expeditious steps are taken for service of the summons upon the contesting defendants, upon the defendants with regard to the pending Miss Case as also the suit. and thereafter proceed to dispose of the missed case within a period of 3 months from date of communication of this order. Thereafter, the suit shall proceed in accordance with law and disposed of preferably within a year.
Now kindly indicate the order civil miscase number, my lord. 11 of
Case
16.
number 11 of 2016.
Great, my lord.
Now, in accordance with law, independently will be arranged. Upon allowing the parties to contest the same, and file necessary objections. Yes.
My lord, I am for the petitioner. My lord, petitioner is the widow of the since the plaintiff died, my lord, petitioner filed substitution application that has been allowed. My lord,
What do you want?
expedite hearing of the title suit, my lord, for
Oh, no, nothing is pending, no
no
application.
application is pending, my lord.
The petitioner is the
Plaintiff.
The petitioners are the plaintiffs in title suit number 277 of 2020, which is pending before the learned civil judge, third court at Sirampur. Junior division, senior division, what? Junior division, third court at Sirampur.
Junior division.
It is submitted that no applications are pending.
And most of the time defendant took time, my lord, took adjournment.
Accordingly, are pending. তারপর যেগুলো থাকে দিয়ে within 1 year. Mandatorily লিখবে না, preferably. এটা তো preferably 22-20 সালের suit. Yes, next. Should be disposed of expeditiously, preferably within 1 year from the next date fixed. তারপর যাবো।
What you want? My lord, may I say one thing, my lord? This is not an application for expeditious disposal, but wrongly I have mentioned before the.
Normal list যাবে।
My lord, but there is some urgency, my lord. Kindly fix any date, my lord.
No, this is not the way to get it fixed. Let the matter, as the matter does not relate to expeditious disposal of a proceeding, let the same be listed as a motion, as an upgraded motion.
Great, my lord. Great.
না, next monthly list তো কালকেই বেরোবে, করা যাবে না তার পরের monthly list. The monthly list of August. Yes, next.
This is my application, my lord. I am plaintiff petitioner before your lordship. 2010 suit has been decreed. Title declaration and injunction suit. Decreed thereafter, order 9 rule 13 filed by the defendant.
Next party.
Yes, thereafter, order 9 rule 13 dismissed. Order 9 rule 9 filed by the defendant. That has been abated. They have filed an miscase. Order 22 rule 9 for setting aside abatement. This miscase is pending. I am trying before your lordship to dispose of the miscase 102 of 2022.
The petitioner prays for expeditious disposal. The petitioners are the plaintiffs in title suit number 02 of 2002. The petitioners an ex parte decree, the petitioner's cartoon, an ex parte decree was filed in favor of the petitioners.
Order 9 rule 13 filed by the
An
defendant.
application for setting aside ex parte decree was filed by the defendants. The said application was dismissed.
Dismissed for default.
Was dismissed for default.
Against
After an application for restoration of the miscase was restoration of the
Order
said
9 rule 9.
application was filed. Right. Under order 9 rule 9 of the Code of Civil Procedure, which has been registered as miscellaneous case number 102 of 2022.
No, my lord. That has been registered 16/2014.
Which was registered as
16 to
case number 16 of 2014. The said miscase was also dismissed.
said miscase was abated. Against that, they have filed order 22 rule 9, that is
Who died at that time?
Akbar Ali, one of the
During the pendency of the application for restoration,
Yes. My lord, kindly come to 114 order number 114. It will be clear before your lords. Type copy also is there. 114.
during pendency of Jamie's case number 16 of 2014, comma 1 Abgar Ali, the opposite party therein, died on January 2020.
Yes.
2020. And appropriate steps had as appropriate steps had not been taken. Jamie's case number 16 of 2014 abated against the said opposite party. The petitioner filed an application under or the opposite parties, the defendants.
Yes.
The defendants filed an application under order 22 rule 9.
Next page, Jamie's number. Next page, my lord, kindly see.
The
Next,
said application was registered as Jamie's case number
next page, 102. Next page, 102 2022.
102 of
22.
2022. The said application is pending. The
Next day.
Jamie's case is said Jamie's case number 102 of 2022 is pending. The petitioner prays for expeditious disposal of the same.
Next date, my lord,
Prayer of the petitioner
20
is
July.
justified in view of the fact that the decree holder has been suffering since long. As the decree holder is not being able to enjoy the result of such decree in view of the pendency of the applications.
July 20, my lord, next date.
Jamie's case 102 within 1 month from the next date fixed. Thereafter, the other, if
No other application, my lord. This is the
কেন এটা হলে তারপরে এটা তো আছে পর আছে অলরাইট এটাই চাইছে এটাই করে দিই খালি জেমিস চেয়েছে জেমিস কেসি হবে
The petitioner is the husband plaintiff, matrimonial suit instituted in the year 2012. My lord, kindly seize your lordship's direction at page 90 of this revisional application.
Money is being paid.
Yes. My lord, compliance is at page 96, 97A. Now, my lord, issues were framed on 12th of December 2012. My lord, kindly seize page 121.
My order.
Yes, lordship's order is at page 90.
Page 90, lordship.
Allow me to submit it. You push me. Otherwise, I will not.
Take down.
Now, my lord, kindly seize one thing. My lord, kindly seize page 121. Now, my lord, on the previous occasion, on 7th of December 2012, petitioner husband is examined in chief and deferred on a petition filed by the respondent. What they are doing, my lord, they are filing applications one after another. So I have an innocuous prayer subject to your lordship's approval. My lord, this time there may be a direction to dispose of the suit within a period of a month from the date of communication of the order, my lord. Your lordship's order, your lordship has seen again, my lord. At page 122, your lordship will find after my lord evidence, this was again put back under PH. Well, this is probably not permissible. Subject to correction. They have filed another petition under order 6 rule 17. My lord, order 6 rule 17, they have filed at this stage for amendment of pleadings.
Was that allowed?
No, my lord, that is pending. My lord, they are going on filing applications one after another.
That they can't file. Can I say that?
My lord, I am only beseeching, subject to your lordship's approval, along with all applications, this may be disposed of within a period of 1 month, my lord.
1 month?
My lord, that is my prayer. Lordship, earlier there was a direction from your lordship to dispose this off within a period of a year. So, my lord, after that order, my lord, 3 years have already elapsed.
Husband is the petitioner in matrimonial suit number 38 2014, which is pending before the learned additional district judge, 6th court at Alipur. It is submitted that the alimony pendentility has not yet been decided.
No, my lord, that has been decided. Even they have filed for enhancement, that is miss case number 235 of 2021. After filing, they have not pressed it. They have withdrawn their prayer. This is their conduct.
And you have written in your prayer alimony pendentility, custody.
My lord, the custody petition, they are filing one after another, seeking visitation. My lord, when there is a separate proceeding has been initiated before the district judge's court, that I have stated in my petition. My lord, this is the petition.
Copy, এটা একটা copy দাও।
কি বললাম?
এই copy, হ্যাঁ, উপরে।
Yes, my lord, this is the copy of this that is pending.
Said
The
matrimonial
grandfather has filed this.
Why grandfather?
My lord, the child is staying with the grandfather.
Since birth.
And where is the mother staying?
My lord, mother is staying differently.
And father staying
No, my lord, father, due to his official work, my lord, sometimes he's staying here, sometimes he's staying elsewhere, outside Calcutta.
Child is with the father.
Yes, grandfather.
Anyway, কি বললাম? না, petitioner হয়, ওখানে plaintiff হয় না।
তোমরা দুজনে কি একটু বসবে?
Several interim applications are being filed. Interlocutory applications are being filed by the wife only to stall the proceedings. It's also submitted that evidence of the husband had started and thereafter deferred due to the other applications which were filed by the respondent. Further allegation is that made that several applications for visitation have been filed in the suit, although an Act 8 case is already pending before the learned district judge. Next paragraph. Reference has been made to the order passed earlier by this court by where the court was of the view that the matrimonial suit should be disposed of within a year, provided the maintenance pendentility is paid regularly by the husband. Next paragraph. An application for enhancement of the maintenance had been filed by the wife, which was subsequently withdrawn. Next paragraph. একই সঙ্গে. Now an application, না, ঠিক আছে, taking note of the proceedings and the order sheet which have been annexed to the revisional application, this court is of the view that the prayer of the husband for expeditious disposal of all interim applications, as also the title suit, is justified.
Matrimonial suit.
All interim applications within the next 3 months from the date fixed, and thereafter suit shall be disposed of within the following 4 months. No adjournments, and provided of however such the time period fixed by this court shall be binding upon the learned court below only if the husband continues to pay the maintenance pendentility as has been directed by the court, directed in the proceeding. In case of default, the suit shall remain.
My lord, your lordship has directed all interlocutory applications to be disposed of within a period of 3 months, then another period of, my lord, kindly make it 3 months, my
The
lord.
time period as mentioned herein above shall be treated as mandatory. Yes. হয়ে গেছে?
My lord.
Lordship, I am for the petitioner and defendant before the learned court below, your lordship.
Yes.
Lordship, the plaintiff opposite parties are enjoying the ad interim order of injunction, your lordship, and the next date is fixed on 10th of July for the hearing of the ad interim injunction, and written statement and written objections are all complete. So I'm just praying, your lordship, the ad interim application is disposed of
Injunction application. They filed their objection.
I am the opposite party here.
You are the defendant.
I am the defendant there. So I have filed my written objection.
Petitioners are the defendant numbers 1 and 2. Entitled suit number 60 of 2023, which is pending before the learned civil judge senior division first court at Barashat. The defendant prays for expeditious disposal of the application for injunction It is submitted, the written objection to the said application has been filed.
as well as a written statement also.
It is also submitted, the written statement has been filed. No other applications are pending as of now.
No, another application has also been made for the local inspection, Your Lordship, pertaining to the.
Apart from the application for injunction, an application for local inspection has also been filed. Considering the nature of the threat, this court directs that the application for injunction as also the application for local inspection be disposed of within the next 3 months from the date of communication of this order. Everybody has been served. Is ready?
Lordship, service is complete because service is upon them because.
All right.
Lordship, next date is fixed on 10th of July.
Within 2 months, the 3 months from the next date fixed, thereafter the learned court shall proceed with the expeditious disposal of the suit.
Lordship, my humble prayer is if the time limit can be constrained to.
23 suit cannot be fixed.
And no unnecessary adjournments, Your Lordship, if my Lord can direct.
Disposed of 7,000 per month and 10,000
Can't apply my mind. Come tomorrow.
tomorrow.
হ্যাঁ ওটা কত নম্বর ছিল চন্দন নিল ওই তো আইটেম নাম্বার 32 or you serve the wife and come which is better. The 32 the order court petitioner is directed to serve a copy of the divisional application upon the opposite party wife as this court is of the view that in case of the matrimonial suit an ex parte order of expeditious disposal may not be proper without hearing the wife. রাখো হচ্ছে ওই 26শে জুলাই affidavit of service to file on the next date.
After recess will from 27 will be taken up.
After recess কি আছে ফিক্সড আছে না একটা আসবার নেব না যখন আসে না নেয় না তো 2:30 সময় একটা ফিক্স আছে
No, 3 p.m. fixed.
I will continue with urgent motions. Yes.
Grateful.
Yes, Mr. Sen, which is yours?
28.
Yes, I will take them from 27.
বসলে প্রথম ম্যাটার করতে হবে আমার 27
সেটাই তো দেখছি
না ঠিক আছে আপনি তো ঠিক আছে তবে 27 থেকে নেবে আবার আর 27 থেকে নেবে
ওরা কথা বলে আপনিও কথা বলেছিলেন ওয়াক অফে
হ্যাঁ
এক্সপেরিয়েন্স
Stay was allowed.
Allowed without hearing, and moreover, my lord, this is not an appeal under section, under order 41 rule 11.
You in the interim, when before the trial court, what happened?
Trial court below status quo has been granted. Thereafter, they have challenged this order in appeal. Appeal court, my lord, I appeared before the appeal court, my lord, before passing of order of stay, my lord. Hearing should be given to me, my lord. This is not an appeal under order 41 rule 11, my lord. This is an appeal under 43. And my lord, if your lordship kindly takes pen to page 22, 23 and 24.
When is the next date fixed?
My lord,
Your lordship,
20th of July, by this time
20
they are
July, your
continuously, my lord, making construction, my lord. That is their purpose, my lord. In the trial court also, my lord, how the trial court has passed this order, if my lord, I have annexed this order, can you see? Can you see? Page 22, my lord, the first appearance, they prayed for filing of W of my written of my injunction application.
What has happened to the stay application?
The application status quo has been granted.
And it is pending.
Yes, it has been extended. Thereafter, my lord, they have preferred an appeal under order 43. And the appeal court, my lord, passed this blanket
What
order.
is the order of injunction?
My lord, 12/5/2023, my lord, page 23. Running page 23. Prior to that, my lord, the conduct of the opposite party is also, my lord, quoted by the learned trial judge, my lord. Initially, they prayed for W. They didn't file.
23.
23, yes. 23, my lord, order number 5.
Order of stay. Order of status quo, if it is stayed, the main relief is granted in the appeal.
Yes.
What remains? Status quo, let the appeal be disposed of in 2 months' time. Take down. The revisional application is directed against an order dated June 12, 2023, passed by the learned additional sessions judge Vishnupur Bakura. Additional district judge, sir.
Additional.
Vishnupur, which additional? First,
No, my lord, only court.
in Miss Appeal number 01 of 2023, by the order impugned, the learned court.
Your lordship, one indulgence, your lordship. Your lordship, I'm led by Mrs. Pompada Dhawal, your lordship. I'm only praying for 1 day accommodation, your lordship.
This is the order I'm.
Your lordship, I know, your lordship, but then your lordship, may short passover be given, your lordship. Only short passover.
Yes, I'm recording my order. Ask her if she wants to add. I will add that. Ask her to come.
Grateful.
I had passed an order of stay. Were you appearing there?
My lord,
Did you appear?
appeal court. My lord, yes. My lord, what my lord, learned court has said, my lord, since it is a appeal under order 41 rule 11, therefore no right of hearing should be given to the respondent. But it is a appeal under 43. This is not appeal under 41.
43 is also in our court admitted for hearing.
My lord,
Probably that's
my lord,
why.
before passing stay, my lord, notice has to be given, my lord.
All right. May not be. If he is satisfied, he can pass again.
My lord, but by this order, my lord,
That is a different thing. Ki bolna? Of the ad interim, ex parte ad interim order of injunction which had been passed in
12/5.
favor of the plaintiff by the learned civil judge, senior division, Vishnupur Bakura, in title suit number 31 of 2023, dated May 12, 2023. By order dated May 12, 2023, the learned trial court found that The property should be protected. And the defendant should be restrained from, should be protected to the extent that nature and character of the same should not be changed. Prima facie case was found on the basis of the documents produced by the plaintiff inter alia, claiming 0.04 acres of land through inheritance. Such order was challenged in misappeal number 1 of 2023 by the opposite parties, and the learned court below, opposite party, sorry, learned lower appellate court admitted the appeal and passed an order of stay of the ad interim order of status quo without assigning any reasons and without appreciating the fact that such stay amounted to allowing the appeal at the interim stage. Decision, Hada bole ekta ache, du tinte decision ache. Reference is made to the decisions of dash duto ache, tinte ache, diye debo. This court is of the view the proper course of action would be to direct the learned lower appellate court to decide the appeal expeditiously, preferably within a period of 2 months from the next date fixed. The parties will continue to maintain status quo till the disposal of the appeal.
Some portion my learned friend's share is there, and another portion I have shared. With my lord, from the permission, my lord, I constructed a house, and in 3 times.
So what has been there is there, further maintain status quo. Yes, on the suit property. Shall file written objection in the meantime and serve a copy upon the opposite party. Yes.
Within 3 months, appeal.
2 months, appeal and application, stay application all.
Item 28.
Yeah.
May I get a urgent server copy?
Server copy tomorrow you will get.
Why not today?
Along with the application for stay, yes. Now,
May I please your lordship?
Yes.
Instant application has been filed by Patho Bhavan School.
Yes.
Challenging an order for appointment of an advocate commissioner in a pending eviction suit against the school. The school is occupying ground floor of premises number 7, Anil Moitra Road, 2,000 square feet from 1975. 500 students are there. The eviction suit is pending. Your lordship can't straight away.
Now, what is the order?
Appointing an advocate commissioner after 5 years. The entire suit is on the basis of reasonable requirements. There's no prayer for appointment of receiver or commissioner.
What is the commission for?
I kindly come to the points. Commission is kindly their application 108.
You are the defendant in the suit.
The defendant 109. The points which the commissioner is to consider. I'm grateful, my lord. There's no dispute. Kindly 109 the points. The judgment, the learned judge has asked the commissioner to consider the following: area under occupation of the defendant, any temporary construction made, nature of temporary construction, etc. This is no prayer, no, and only apart
Is there
from the
any
stay
MOP
lines.
ground? MOP ground, addition, alteration, all that?
Nothing has done. In fact, our case is whatever we have done under the original landlord, whatever, and we have made not made any construction anywhere, and that is not the case made out in the plaint. Kindly come to the plaint, the main
Number
case.
of students in the roll.
Yes, and these are all sufficient for evidence. These are nothing to do with the property. This is really
Just take down.
investigation.
What is the stage of the suit, Mr. Sen?
We have filed a written statement, it is ready for trial. In fact, we have told them that
Issues have not been framed.
I have to take it, sir. I don't think so.
Yes, yes, what did you want to say?
That we have made a prayer that our building is coming up, we'll move. But they want to evict us immediately. Where will we go?
Who is the landlord?
Landlord is the person who has bought all the premises in that area, including the Weaver Studio, where we often come and go to see the pictures displayed. That place, Baligan Circle, the powerful person. And main case made out is reasonable requirement. I understand that there is no necessary for
So those Kosturi fish and fish, those have also been bought.
No.
Oh, this side. Yes. The petitioner is the defendant in title suit number 70 of 2017, which is pending before the learned civil judge, senior division, 10th court at Alipur. The suit is for eviction.
The order is at page 150, no reason. Just kindly have a look at it, no reason. 150.
The petitioner has challenged an order by which a learned advocate commissioner was appointed for the following.
In respect of points as stated in the petition.
In respect of the points which are quoted below. Where is page 109 থেকে quote করবেন?
109.
Mr. Sen submits that the points for commission are not relevant for decision in the eviction suit. In the that some of the point in the eviction suit and the plaintiff was trying to fish out evidence. Next paragraph. The court file, prima facie it appears that some of the points do not have any implication in the suit, and which is one for eviction on the ground of reasonable requirement. Next paragraph. The prima facie it further appears that the points for commission can be proved in evidence. Next, stay of all operation of the order dated author as also the title suit up to 30th September. Let the matter appear on 8th August. 8th August. Order dated so as also the title suit. No, order dated is title suit order dated June 2, 2023. 2 p.m. 8th August, 2 p.m. 30th September.
I'll serve.
Service. August 8, 2 p.m. And service, affidavit of service, interim order, stay of operation of the order, so and so. The suit may proceed.
29.
29, my lord, this is my lord, I appear for the opposite party. My lords, we have not been served. My lords may direct service and we can come back tomorrow.
You have filed caveat?
No, my lords.
Then
My lords, I am being led by Mr. Probal Mukherjee. My lords may direct a service.
if I do not admit the revision of expectations, then how does it matter?
My lord, order of my lord 5th June 2023 passed my lord in a civil suit, my lord, relating to my lord company, my lord, which has been, my lord, under the Insolvency and Bankruptcy Code. A resolution plan passed, approved right up to the Honorable Supreme Court and resolved.
And then what happened in those?
And then, my lord, what happened? No, my lord, now what has happened?
My lord knows financial creditor had filed, my lord, they filed, my lord, a section 7 proceedings before, my lord, the IBC. My lord, it's barred. Civil court has.
Banerjee, the way you are talking to me as if I know everything about the NCLT and the Companies Act.
My lord, I always proceed on the basis that my lord knows, my lord.
This is not the way.
Okay, my lord, may.
It has to be an educational journey.
No, my lord, I won't dare do that, my lord. I know, knows, because my lord, also, my lord, the order is there, my lord, when, my lord, someone came up, my lord, from the NCLT, my lord, with Article 2 to 7. My lord, I'll tell, my lord. My lord, knows under the Insolvency and Bankruptcy Code. My lord, first of all, my lord, that has exclusive jurisdiction insofar as the company is concerned, which has got into, my lord, a corporate insolvency resolution process. That is section 238, is one of the barring provision. Now, my lord, there is a process under the Insolvency and Bankruptcy Code when it gets into what is known as, my lord, we call it CRP, my lord, in that sense, corporate insolvency resolution process. Then, my lord, a resolution plan is submitted, saying that how the company should be resolved.
Revived or whatever.
That's right. Resolve, revive, my lord, that's the same thing. Then, my lord, a resolution plan is approved. Then whatever is, my lord, in the resolution plan is what is, my lord, dues to all creditors. Because it's someone else coming in, resolving the company, then all rights are in terms of the resolution plan.
Yes.
My learned friend's, my lord, client is, my lord, an assignee from one of those banks, financial creditors. Original, my lord, creditor of, my lord, the company, who's, my lord, an assignee of that person. Let us, my lord, take it, my lord, he's the bank, he's, my lord, the financial creditor. Now, my lord, he has been resolved in terms of, my lord, the corporate insolvency resolution process plan, which has been, my lord, approved. It went up right up to the Supreme Court. Very highly contested matter, went up to the Honorable Supreme Court, plan, my lord, approved. So he is only to, my lord, get payment.
Amount, money.
That's right. In terms of the resolution plan. And, my lord, he is to, my lord, release everything, my lord, so far as, my lord, those debt is concerned, including, my lord, the no objection, everything, because he has his claim so far as the company is concerned, that is fructified. And if he has, my lord, any claim against the guarantors, that's a different issue, my lord, not concerned. Now, he has got that. Now, what he does is, my lord, goes to a civil suit. First, my lord, he files the suit, my lord, before the senior division and obtains an order saying, my lord, that the company, which is, my lord, the resolved company, cannot deal, my lord, with its assets.
Okay.
Which he cannot, because, my lord, he's already, my lord, in the resolution plan, my lord, everything is taken care of. Then, my lord, he withdraws. He obtains an order, he withdraws that suit. Then, my lord, goes, files another suit before, my lord, junior division. And, my lord, obtains the same order. My lord, I have come up in revision saying, my lord, this order is, my lord, wholly without jurisdiction. He could not have, my lord, gone to, my lord, any civil court to, my lord, obtain an order, my lord, which is against the provisions of the resolution plan, as well as, my lord, against, my lord, the whole, my lord, insolvency and bankruptcy code.
So what
It's,
is the
my lord,
order he has obtained?
my lord, he is obtained, my lord, and kindly see, my lord, page 6. After the last, my lord, and I'll show the previous order, my lord, which you also obtained. My lord, this is an abuse of the process, my lord. That's, my lord, my submission, and wholly without jurisdiction. Because I have already paid, my lord, 351 crores. Crores, my lord, under the plan.
No, order impugned?
Yes, my lord, this is, my lord, the last annexure, my lord, in volume 4. After, my lord, it's 676, my lord, the last annexure, I'm sorry. This is a suit for declaration injunction valued
An
at.
order of injunction.
Yes.
Then I don't have jurisdiction. It's an appealable order.
Fine.
Then
My lord, wholly without
My lord.
jurisdiction.
isn't it? It's an
My lord,
appealable. That's
My lord,
the
I just want to show, my lord.
My lord sees the order. My lord sees the order.
My learned friend is not on
An appeal has to
cabin.
be filed.
My lord, under 2 to 7, my lord, I can, the jurisdiction of the High Court, my lord, is not taken away.
It's not, but there is an
lord,
efficacious remedy. He has given.
My lord,
a
no
recent
efficacious
order.
remedy. My lord, he could not have obtained, my lord, any order. That's what I'm saying.
No, that is on the merits of the whether suit is maintainable or not.
Without jurisdiction, on the face of it, my lord, I can show.
That is for me. This is
My
an
lord,
appealable
My
order.
lord, it's a bar, my lord, under the Insolvency and Bankruptcy Code.
Yes, but that is order 7 rule 11. I could have entertained, but this is an injunction with
My lord,
reasons.
I have
So it
no,
is
my lord,
an
there are no,
appealable
no,
order.
kindly come to, my lord, there are no reasons. Kindly, my lord, see, my lord,
Whatever that, yes, enough reasons for
my lord, kindly sees plaintiff states, my lord, third line, it's an asset reconstruction company. On 23rd April 2021, plaintiff entered into an assignment deed to acquire the debt of defendant number 1. Defendant number 1, my lord, is the company which has been resolved.
for consideration of rupees 245 crores. Now 351 crores, my lord, already received. The plaintiff holds over 77% security interest driven one land Sansaj Kollani. Then my lord goes on. Then says pleadings of the plaintiff and documents cannot have sufficient basis and successfully advertise a prima facie case. Go to trial as Sansaj. In my opinion, at this early stage of litigation, the plaintiff is not given protection to suit property. Then my lord, injunction is passed. Ordered that the prayer of adjournment is hereby considered. Lord ex parte have constrained from creating any third party. Now, my lord, kindly look at the plaint, page 44, volume 1. Kindly see, my lord, CFM asset, sorry, my lord, page 43, really, my lord. CFM, my lord, is the creditor, my lord, who says obtained and Ram Sharup Industries, my lord, is, my lord, the defender one, resolved company. And my lord, kindly look at, my lord, this is the last order, my lord, which has been passed, my lord, also, my lord, by the National Company Law Tribunal, my lord, on the same issue.
My lord, there's an application for stay pending in this very writ court, which was
Well,
which is listed
order has
today,
been
my
passed
lords.
on 27 June.
That order has been appealed, challenged before this writ court in the writ proceeding which was
I have
pending.
not finished.
This order, my lords, which has been handed over to my lords.
This is 27 June.
Yes.
What are you talking about?
There's an order of there's an application for stay, my lords.
Well, lord, kindly look at, my lord, this order. My lord, here, my lord, respondent, my lord, the cost title, my lord, will find Ram Sharup Industries Limited, my lord, which is the corporate, my lord, debtor.
Paragraph 2021.
Then, my lord, SS National, my lord, is the resolution applicant. And then CFM, my lord, is my learned friends, my lord, client plaintiff.
2021.
This is the last order passed. And, my lord, kindly look at paragraph 21 at page 7, my lord, of the. No. It is not contested that the SRA, which is, my lord, the company, sorry, my lord, page 7, has deposited the entire amount. My lord, has that, my lord, paragraph 21. I'm sorry, my lord.
Which
Paragraph 21. Yes, my lord.
Paragraph
21. This is, my lord, relating to the same subject matter and, my lord, the same company and, my lord, the respondent here. Paragraph 21. It is not contested that the SRA has deposited the entire amount in a control account as directed with the audited 6 April 2020 of the adjudicating authority. It is also not contested that the approved plan has achieved finality, having been carried up to Honorable Supreme Court, who has upheld the same and consequently depositing of the plan money in the said control account. SRA is quite clearly and justly agreed that even after depositing the amount, plan amount as per plan, it is not being issued the no due certificate, along with title deeds of the property, for which he has already made the agreed payment way back in the year 2022. Such massive roadblocks in the path of SRA are quite capable of shooing away the genuine entrepreneurs from venturing into attempting to bid for the corporate debtors and put them back on their feet, seriously jeopardizing very intent objective of the court. Then XRP, Molot, that's paragraph 23.
29.
Then Molot, kindly come to paragraph 29. And the same person, Molot, is the respondent.
29 last.
Page 14, Molot, we'll see. '29. Fine. Finally, we make a remark that the object of court is to revive a corporate and not to drag it to the grave. The SRA, despite of the huge number of litigations passed and
What
passage
is
of,
the nature of injunction pass? Not to transfer.
yes, and the same property, in respect of which has been directed, Malad, now Malad to give over the title deeds to us. SRA, despite of the huge number of litigations, passage of time not back and wants to revive the corporate debtor, the respondent should try to take a logical approach and not stand as a wall in the revival corporate and the implementation plan after 3 years.
Yes, but then even then, Mr. Banerjee, you have to go and file a first miscellaneous appeal.
Malad, he's one of the respondent. He's one of the respondents.
Yes,
there.
I will record your submissions, but you will have to file an appeal.
And my lord, this is my lord's judgment, my lord, when my lord, they came up, my lord,
NCLT without any jurisdiction.
my lord, here, my lord, civil court also, my lord, without any jurisdiction.
But this is an injunction order passed.
My lord,
Upon appreciation of
NCLT,
the
my lord,
facts
appeal is also, my lord, to the,
case.
my lord, NCLT appeal is also to the NCLAT.
No, that
227,
is
my
a
lord, should not have
tribunal.
been.
When a court, this is a court, civil court. From the orders of a civil court in the injunction stage, you are supposed to prefer an appeal. So when there is an appeal, why should 227 be entered?
My lord, same thing, my lord, here.
No,
my
no,
lord,
this is not about an alternative remedy as per a statute. This is a proper civil court hierarchical allotment or assignment
my
of
lord,
cases.
here also, my lord,
Like that.
NCLT, NCLT, and my lord, Supreme
I
Court.
cannot direct that the civil court was without acted without
No,
jurisdiction.
my lord, I
because
want, my lord, that question, my lord, to be looked at by my
it
lord.
will be looked at, but I can't look at it now because this point was not before the civil court when they
My lord,
passed an ad interim order. It is just about alienation. So RIP personnel is not going to alienate.
my lord,
You are not going to alienate.
it is my property. I've already paid 351 crores.
All
My lord,
right.
the NCLT holds. My lord, may I just?
That is not his property.
But
Well,
it
That
has
is the
to be
point of,
done.
my lord,
Well,
there
may
are
I just-
disputed questions of
Kindly
fact
look
which
at
has to be
this.
decided, my lord. It cannot be done in 220.
No, my lord, no, my lord's judgment, my lord.
This
But
is-
kindly, my lord, may I try and, my lord, persuade my lord on
This
this, my lord?
was lack of territorial jurisdiction of the tribunal. Isn't that it?
I am on subjective jurisdiction here, my lord, lack of subjective jurisdiction. Paragraph 14, my lord, will kindly
That
come
is
to.
an appeal. You prefer an appeal and raise those points.
My lord, may I
You
just?
file an order 7 rule 11. Otherwise, unless it is that is before the learned trial judge, the trial judge on the plate found a prima court did not find that it was a bar. And you can take that point over there. Nobody is stopping you. But it can't be a.
My lord, an application
My
of
lord, may I
order
just
13
show-
and rule
my
4
lord-
has not even been moved. They have not even entered appearance.
My lord-
My lord looks at the
It
order.
is a, my lord, they have obtained an order ex parte. First going to the senior division, obtaining an order ex parte. Before, my lord, we could go to the senior division, they withdrew it and went and filed before the junior division and got an order.
And they had
If
1
I
month
show, my
time
lord,
to
all
approach
this-
the court. They have not
If I
approached the
show-
court.
my lord, we have filed this revision petition, my lord, immediately.
No,
My
my
lord,
lords. They have filed
please,
it after 2
let me-
weeks, my lords. That is a wrong
kindly
submission.
Look at, my lord, page 45, my lord, of plain 44, 45. And this is also pleaded. Obviously, my lord, they didn't want, my lord, to fall foul of what they have done. Page 45. My lord, this is part of the plaint. No, so kindly see, my lord, plaint in the
Psalms agreement in the, look at the prayers.
my lord, kindly, my lord, take, my lord, the plaint. My lord, my lord, because he has to, my lord, page 44, kindly look at page 44.
Yes.
CFM is a company incorporated and 3 says asset reconstruction company. Then kindly, my lord, turn over and see, my lord, paragraphs 6. That is in or about 2018, different number 1 went into corporate insolvency resolution rules under the provisions. 7, that a consortium of SS Natural Resources Private Limited, which is one of the resolution applicant, and Shamsel Sansad were a successful resolution applicants in different 1 by way of NCLT Kolkata's order dated 4th September 2019. So it is already there. Then they entered into that on 23rd April 2021. So, my lord, after the resolution.
They have pleaded sale of scrap, so they are worrying about that. Some agreement. Now that is not a part
That's
of
the assignment deed they're talking about. Mullah, they say, Mullah, they have been assigned. Kindly see, Mullah, after the resolution plan has been already approved, that on 23rd April 2021, plaintiff entered into an assignment deed with asset reconstruction to acquire the debt of defendant 1 for a consideration of rupees 245 crores, a copy of the assignment deed. So, Mullah, the insolvency is there. Resolution plan has been approved. In paragraph 7, they say that. And then, Mullah, they go in respect of the same defendant number 1 and corporate debtor and Mullah obtain orders. Mullah, this is what I'm on. It is not that, Mullah, the plaint, Mullah, is correct. If it was totally, Mullah, a suppression where, Mullah, nothing was mentioned. But here, Mullah, quite naturally, they also wanted to save their, Mullah, if I may say so, Mullah. Then, Mullah, that's why paragraph 7 that is mentioned. That should have, my lord, immediately, my lord, rung, my lord, at least, my lord, some question of, my lord, giving, my lord, notice, or, my lord, finding out, my lord, whether what is the issue. This is, my lord, wholly without, my lord, jurisdiction. And, my lord, 231, my lord, will see, my lord, of the, my lord, insolvency and bankruptcy code. My lord. I'm sorry, my lord, this is, because, my lord, knows, my lord, if I going back there, my lord, means, my lord, this is what they want.
No, I will tell you how, I will put them to terms, and the learned court, I will direct you file your
My lord, 231, kindly, my lord, have a look, my lord.
Take down.
My lord, 231, my lord, there's a bar, my lord, with regard to.
31.
Tahle
Relying
appeal
on
korbe na, ki appeal
the
korbe.
provision of section
Order
231 of
711.
the Insolvency and Bankruptcy Code 2016.
Charge code.
The defendant in title suit number. I will write everything you said. That much I'll.
My lord, kindly, my lord, then, my lord, may I just,
Yes.
some, my lord, so that, my lord, if I either, my lord,
Yes,
appeal
yes.
or an order 711, my lord, whatever, it has to be disposed of within a certain period.
Yes.
Otherwise, my lord, the interim order should be, my lord, go.
Number 113 of 2023, which is pending before the learned civil judge, bracketed junior division at Kolkata, Nodia. The revisional application has been filed alleging that the order dated, challenging the order dated June 5, 2023, passed. Stop. The order impugned is an order of ad interim injunction which has been passed by the learned trial court. Mr. Banerjee, learned senior advocate, submits that section 231 of the hereinafter referred to as the said court of the said court bars the jurisdiction of a civil court in respect of matters which are to be dealt with in accordance with the code. Taking the court through the different paragraphs of the plaint, Mr. Banerjee submits that the entire issue with regard to the insolvency and bankruptcy of the company, the corporate insolvency resolution process, and the ultimate acquisition of the property by Mr. Banerjee's client had been dealt with and the entire issue with regard to the bankruptcy of the which company went
My lord,
bankrupt?
Ram Sharup, my lord. Ram Sharup Industries Limited.
Of Ram Sharup Industries Limited, which is the defendant number 1 in the title suit, comma, the corporate insolvency resolution process, and the ultimate final acquisition of the company which went into liquidation by the
Went to CRP, my lord, went into, my lord, insolvency resolution.
Okay.
Liquidation, my lord, is subsequent.
acquisition of the company you got. No?
Yes, my lord. That is, my lord, in CRP. The process, my lord, is corporate insolvency resolution process.
And the corporate insolvency resolution process and final acquisition of the property, vesting of the property. What is
Yes,
it called?
what happens, my lord, when there's a plan, my lord,
Complete.
whoever is the resolution applicant gets the company itself. Resolution applicant.
The acquisition acquisition of the company by the petitioner.
No, by my lord, SS natural, by the successful resolution applicant will do.
By the successful resolution
Applicant.
Had been finally adjudicated and decided up to the Honorable Apex Court.
Yes.
Thereafter, opposite party had tried various means to disturb the operation by the petitioner. You are the petitioner here?
Yes, one of the corporate, the Ram Sharup is the petitioner.
By the CRP applicant.
Disturbance, my lord,
Successful.
disturbance, my lord, to the resolution plan. It should
Had caused several disturbance to the resolution plan
implementation of resolution.
and implementation thereof. It is specifically urged that an amount of rupees 51 crores was spent in the process.
Yes, was paid, my lord, in terms of the resolution.
Paid to the
In terms of the resolution
in terms
plan.
of the resolution, the plaintiff represents a bank.
My lord, assignee of my lord, an asset reconstruction. He is also an asset reconstruction.
Plaintiff as the assignee of an asset reconstruction company, instead of fulfilling its obligations in terms of the resolution plan, obstructed in the smooth execution of the same.
Absolutely. That's my submission.
The plaintiff also filed suits surreptitiously by trying to stall the process. Once that suit was withdrawn,
yes,
and thereafter the present suit was filed, which is the subject out of which the order impugned arises. Mr. Banerjee submits that the pleadings itself would indicate that the suit was barred as the averments totally related to the process of corporate insolvency resolution. Prayers have also been the subject matter of the suit and the prayers therein are all covered by the corporate insolvency resolution process. Next paragraph. According to Mr. Banerjee, the order suffers from lack of subject matter jurisdiction, and this court, by invocation of power under Article 227 of the Constitution of India, must set aside the order impugned by which an addendum order by which the petitioner or the successful
resolution
applicant, the successful resolution applicant was restrained from transferring, alienating, or creating third-party interest in the property which has vested in the said applicant. Next part.
We also came, my lord, because there was a not to pass adverse order, my lord, which was going on. We have about that in paragraph 24. Before, my lord, the Kolani court.
It is submitted that such order was passed when the resolution had been adopted by the local bar.
When, my lord, we came, my lord, it was not to, yes. It hasn't due to resolution not to pass in advert.
And today the court is vacant.
Vacant.
The day the order was passed, there was a resolution.
No. My lord, the order was passed, my lord, on 5th. Oh, she didn't know resolution. Yes, my lord. That day also was there.
On a day when the local bar had adopted the resolution
2nd June.
that the court should not pass
And 23rd June.
adverse orders.
23rd June.
এটা রিসেপ্টটা 3 দিন ফাইল করেছি সেদিন লাগিয়েছি
ঠিক আছে
It's 2nd June.
What is your name?
Hello, Dipanjan Datta Roy.
Mr. Dipanjan Datta Roy, learned advocate appearing on behalf of the opposite party.
Number 1.
Parties.
Oh, no. Number 1, I think.
Plaintiffs are 2, no? Opposite party number 1.
Yes.
Submits that the revisional application is not maintainable, that the contentions of Mr. Banerjee of his client having paid up the entire amount as per the settlement resolution plan was also incorrect. Next part. Having perused the order impugned, this court is of the view that upon appreciation of the materials on record, an interim order of injunction was passed. Such order is an appealable order, and the Code of Civil Procedure specifically provides how an appeal provides how an appeal should lie from an order passed by the learned trial court, allowing a prayer for ad interim injunction. As there is a specific provision of appeal under this code, which is a complete code, in jurisdiction of this court, it cannot be invoked at this stage in this proceeding. The petitioner has other options open to challenge the maintainability of the suit, as also the order passed, ad interim order passed, by approaching the appropriate forum. The petition, if the conditional application is not entertained, liberty is granted to the petitioner to prefer a misappeal in accordance with law. If such misappeal is preferred, the same shall be disposed and pray for. The same shall be disposed of within a month from its filing. All points with regard to maintainability, jurisdiction, etc., shall be decided by the lower appellate court. Now, all points relating to the jurisdiction of the learned trial judge to issue the order of ad interim injunction and to entertain the suit, etc., shall be decided by the lower appellate court. Now, entertain the suit to issue an order ad interim injunction shall be decided by the learned lower appellate court. A copy of the memorandum of appeal and any application filed therewith shall be served in advance to the opposite party number 1,
Certified copy.
so that the appeal may be expedited.
Certified copy. My lord, can we, my lord, obtain the certified copy, my lord, and my lord, by keeping a copy, my lord, here?
Liberty is granted to the petitioner to take back the certified copy of the order in view upon furnishing a photocopy thereof.
I'm grateful, my lord. I'm sorry, my lord, we trouble, my lord, but the nature of the order, my lord, we thought, my lord, we must, my lord.
I don't mind being troubled. It's my job, so that's all.
No, certified copy of the order under appeal.
তাড়াতাড়ি এটা ইয়ে করে তাড়াতাড়ি ইয়েতে
file করতে হবে।
নাহলে ওরা সার্টিফাইড কপিটা নিতে পারবে না। I will do it in first এটা একটুখানি একটা স্টিকার দিয়ে দেবেন, আমি আজকে শুই।
I'm grateful, my lord. Grateful.
এটা একটু ওখানে রাখো, ওখানে রেখো।
Grateful.
ওদের বই না?
Great.
Yes, next. কেমন আছে নাকি? হ্যাঁ, ডাকো ডাকো চিপে বলো। এটা নট টুডে করে রেখে দাও, পার্থ চলে গেছে কোথায় আবার। টপ ফিক্স 1 না 2 কত নম্বর আইটেম এটা আছে? Yes.
CPM matter item number 14.
সার্ভিস হয়েছে? আসে না সার্ভিস করলে।
Both.
Mr. Chatterjee, you're matching your watch and your phone cover, or is it a set? Really? A nice color. I like it. No, it's nice. Yes.
Kindly see your lordship's last order, my lord. Lordship has recorded a detailed order.
That's a moment. It goes off. Seriously. Yes, what you want to show, Mr. Water?
Kindly comes to page 9.
Yes, read the plane.
This is the plane.
আমি প্লেন দিতে পারিস না টাইপ করে কি অবস্থা প্লেনটা আমি পড়তে পারি
My lord, kindly see the
read the relevant paragraph.
yes, kindly comes to the prayers at page 13.
13.
Yes, my lord, prayers.
Yes.
Kindly comes to ক তফসিল সম্পত্তি ভুক্ত সম্পত্তিতে বাদী সত্য সাব্যস্ত বিবাদীগণ সত্য বাদী খ তফসিল ভুক্ত জমি খাস দখল অন্তে এবং ক তফসিল জমিতে বাদী শান্তিপূর্ণ দখলে বাধা সৃষ্ট করিতে না পারে তৎমর্মে বিবাদীর বিরুদ্ধে চিরস্থায়ী নিষেধাজ্ঞা ডিগ্রি দিতে আজ্ঞা হয় খ declaration of title permanent injunction. Then মিলট খ নালিশির খ তফসিলভুক্ত সম্পত্তিতে বিবাদীগণের কৃত কনস্ট্রাকশন ভগ্ন পূর্বক খাস দখলে ডিগ্রি দিতে আজ্ঞা হয় রিকভারি অফ খাস পজিশন নাও মিলট কাইন্ডলি
মানে breakdown demolition recovery
encroachment. This is a suit for alleging encroachment. Now milord, the cause of action is not that. Kindly see milord the previous page, page 12. Page 12, paragraph 5.
Yes.
গত ইংরেজির 27/8/2017 তারিখে বিবাদীগণের অন্যায় লোভের বশবর্তী হইয়া নালিশি ক তফসিলভুক্ত জমির অংশ পুনরায় এনক্রোচ করিয়া কনস্ট্রাকশন কার্য করিবার চেষ্টা করায় নট করে এবং তফসিলভুক্ত সম্পত্তিতে পুনরায় কনস্ট্রাকশন করিবার চেষ্টা করায় বাদী বিবাদীগণের এই রূপ বেআইনি কাজকর্মের প্রতিবাদ করিলে বিবাদীগণ বাদীকে শাসনী সুশুরি দিতে করেন ইহার ফলস্বরূপ বাদী উক্ত
WS has been you are the defendant.
I am the defendant.
You filed WS.
Yes. ফলস্বরূপ বাদী উক্ত বিষয় বিবাদী বিরুদ্ধে মহামান্য বারুইপুর এক্সিকিউটিভ ম্যাজিস্ট্রেট আদালতে ফৌজদারি কার্যবিধি আইনের 144(2) ধারা মতে ইংরেজি 31/8/17 তারিখে একটি দরখাস্ত করেন যাহার নম্বর MP সাচ এমত অবস্থায় বিবাদীগণের পুনরায় গত ইংরেজি 26/10/2017 তারিখে নালিশি ক
This is an attempt to encroach.
Exactly. This is an attempt to encroach. Therefore, the at best they can get milord prayer permanent injunction, not recovery of possession. Now, milord kindly comes to the written statement at page 17. Page 17. Lordship has come. Now, milord kindly comes to the relevant portion as
খাস দখল অন্ত ক তফসিল জমিতে বাদীর শান্তিপূর্ণ দখলের বাধা সৃষ্টি করতে না পারায় আচ্ছা So there is no allegation of that
encroachment.
This much has been
encroached. Trying to encroach, but not encroachment. Now, milord kindly comes to the written statement.
Yes.
It starts at milord page 17.
Page
17. Kindly comes to the relevant portion at page 27. Now, milord kindly see the second paragraph. হাল RS জরিপের পর্চায় সন্তোষ ঘোষের নামে রেকর্ড হয় সন্তোষ ঘোষ নালিশি সম্পত্তি চারুচন্দ্র ঘোষ ও ওয়ারিশ থাকে ত্যক্ত 1 থেকে 3 রকম অংশ ইনহেরিট করেন সন্তোষ ঘোষ ত্যক্ত সম্পত্তি তাহার 3 পুত্র নীলমণি প্রশান্ত দুরন্ত ইনহেরিট করেন এই বিবাদীগণ নালিশি সম্পত্তির ওয়ারিশ সূত্রে খরিদ সূত্রে দান সূত্রে মালিক হয়েছে therefore milord we are having a rival claim over the property.
That's okay.
Kindly see the next line. এই বিবাদী নালিশ সম্পত্তিতে অর্থাৎ 425/1191 this is the suit property. দাগে এবং পার্শ্ববর্তী 425 this is non suit property 425/1990 নম্বর দাগে জমিতে একলন্তীয় ভাবে বস্তু
order 39 rule 7 হয়েছে
39 no 26(9). Before framing any issue, court even we do not know whether court will even frame any issue for encroachment. Encroachment will order 26 rule 9 allowed.
Even the issues have not been framed. At the written statement, only written statement is filed, injunction stage. I don't say that they do not have any right.
Not at this stage.
Not at this stage. And provided they can, my lord, make, they have made out their cause of action on the basis of the prayers made in the plaint. On the cause of action is attempting to make. They may get at best permanent injunction. But khaw, my lord, on the basis of the pleadings made in the plaint, prayer khaw, my lord, cannot be
Are they
given.
asking for declaration of title? কর খ তফসিল ভুক্ত সম্পত্তি বাদী সত্য সাব্যস্ত বিবাদীগণ যাহাতে বাদীর খ তফসিল ভুক্ত সম্পত্তি খাসদখল অন্তে এবং ক তফসিলটা কত?
ক তফসিল, my lord, kindly comes to
425 by
425 by 1191.
1191. You are claiming?
I am claiming, my lord, page 27. Page 27.
(425) রাগের 700.
Yes. Yes.
425
Two kata is the entire.
425 1191.
Exactly.
দুটোই 42 তাহলে কর.
No, it's a entire, it's a big plot.
No, I'm talking about the plane.
Yes, my lord.
Schedule of the plane, just see.
Yes, my lord. Yes, core schedule is Jela Dokhin 24 Pargana, Thana Sonarpur, Mauja such and such, jail number such and such, Khotia
number such and such, number.
Tag number 425 by 1191. মোট yes, মোট জমির পরিমাণ 7 শতকের মধ্যে পূর্ব দিকে 5 শতক. Well, that is they say, my lord.
5 শতক.
Yes.
And you that খ তফসিল is how much?
খ তফসিল, my lord, is
পশ্চিম দিকে 2 কাঠা.
পশ্চিম দিকে 2 কাঠা.
So these two, they are saying declaration of title and injunction.
At this stage, my lord, order 26 rule 9 allowed, my lord.
Yes, let them keeping it for orders. I've heard you. Just one notice you give, and I'll pass it. Yes. Heard the learned advocate for the heard Mr. Bhattacharya on behalf of the petitioner. Affidavit of services taken on record. Despite service, none appears on behalf of the opposite party. Let this matter appear on. এই একটা একদিন দাও না, এই বসেই দিয়ে যাও, এটা তো ছোট একটা. Anytime appear on 27th জুলাইতে কিছু আছে? ওটার সময় সকালে না, মানে তো সকালেই থাকবে. হ্যাঁ, তো ঠিক আছে. at 2:30 27 July at 2:30 PM. As a last chance, the opposite party, a further notice be issued upon the learned upon the opposite party as a last chance. Opposite party and the learned advocate ki chini?
Yes, South.
Acha. Upor lekho despite service, none appears on behalf of the opposite party. Both were given.
Both were given.
As also the.
That was your lordship's last direction.
Upon service upon the learned advocate for the opposite party, as also upon the opposite party, none appears to contest this application. Mr. Bhattacharya has concluded his arguments. In order to allow the opposite party one last chance to contest the proceeding, let the matter appear on 27 September, July 2023 at 2:30 PM. Fresh issue of notice along with a server copy of this order upon the opposite party.
Kindly extend the stay, my lord.
The interim order as already passed is extended or 31st of the
August. Great.
দরকার নেই. Yes, next.
Item
Bring up.
15. It's a
The
little
other
bit
side কি?
mine. Item 15.
পাশে বসে he has convinced you.
No, my lord,
He said he just briefed.
just got
Just
the,
received the
just
brief.
was
Very well.
কি হয়েছে?
any day. They just received the brief. It wasn't supposed to.
Not today.
A লোভ তা মানুষের তার উপর I find my lord Mr. David Mukherjee is leading. The even better my lord for me to take up the brief.
দেবজিৎ কোথায়?
Actually, he's in courtroom number 236. Adjourns it on his ground.
What is this matter?
Well, it's an order 7 rule 11 which has been rejected, but what I perceived and what I think it is different, because I think my lord here it can be a 5/8 application which can be termed as an order 7 rule 11, but now I find my lord that there are other facts where my lord the section 11 was actually rejected by this honorable court, and now they've gone back and filed a suit my lord on some other ground which I have to go through my lord.
Baby system is here.
Yes, and
My
we
lord,
say, my lord, that this is under the Transfer of Property Act. It's very sketchy. I will not really say,
Sketchy
my lord.
things has been decided by the honorable court of this court, my lord, under jurisdiction of 11(6).
Allow me to just go through them, my lord. It's not there.
Do you want to?
They're saying
next
tomorrow.
week, my lord.
They're saying
Tomorrow, day
tomorrow.
after, whenever.
তোমার সবই তো ফিক্স করা থাকে।
Day after tomorrow?
কিছুই হয় না, ফিক্সিং হচ্ছে।
Day after tomorrow, শুক্রবার?
না, এই উইকে আর হবে না। ফ্রাইডে তো I have original side of two.
তাও ওদিকে।
Give me a date.
দাদা,
এই,
এটা তোমার ব্যাপার। এবার আমি
ওই যে এর মধ্যে 2-2.5 কিছু আছে।
ব্যবসায়ী দিচ্ছেন।
আড়াইটে কতক্ষণ লাগবে?
10-15 minutes.
Maximum.
Both together?
Together na ho.
Together each
They are trying to do something out of it. And I'll just indicate the facts, 2-3 paragraphs and the decisions delivered by the Honorable Justice Bindal. But that's all. They have taken a point under orders 11(6) and they have shifted that stand in the trial.
We say, what I was told is that they are shifting stands. So I will have to find that.
2-2.5 কিছু খালি আছে নাকি দেখো। এই নেক্সট উইক
তারপরের উইকটা 17-24
না, তারপরে দেখো। তুমি আমাকে দাও ডায়েরি দেখি। 18, 19, 20 3টের সময় আছে। 18 তারিখ 2টোর সময় দিয়ে দাও।
28th.
28 তারিখ
18 18
Good. At 2 p.m. I'm grateful.
দেখো নিউ মোশন ডাকো।
Okay, 45.
145 হয়ে গেছে। 45 42 দেখে যাও।
46, 47, 48, 49.
My lord, for item number 49, I'm appearing on behalf of the opposite party, my lord. We have not got any copy, my lord, for the print.
Pass over, they're not here.
50, 51.
Praying for a short passover.
Yes, Dakur, dekhe jao.
52, my lord, I am for the
Yes.
petitioner.
See the file for 52.
I am for the petition. My lord, I again prefer not to as per my client's instruction.
Then it will be out of list. Tell your client, I'm not going to bring it back. This
As
is
you-
not the way.
As you please, my lord.
Huh? Who is leading you in the matter? Someone leading you in the matter? Why have you been instructed to ask for an adjournment? Because you were ready to do the matter.
Yes, my lord, I was ready, but
Yes, you can tell me.
some person who is close to the petitioner has just instructed me.
Pray for an adjournment on what ground?
My lord, the ground is that but there is a negotiation of settlement between the parties.
Yes, next. Dako, dako. Next time, please tell your friends not to mention any matter. Dako. Short, তাহলে short ই হয়ে যাবে. Yes, go on. দেখে যাও.
51, 62, 63, 64, 65.
Come. বার করো তো ফাইলটা. You start moving it. You start telling me what the matter is till the file comes.
But this is the amendment application was rejected only on the ground at the peremptory stage. No evidence was called on.
What is the nature of
Nature, this is a suit for declaration injunction on the ground of encroachment. The learned advocate who drafted, he died. New advocate when came, a topography was only introduced and the particulars of the encroachment with the area and a map was also attached to the amendment. Court said, no, it is at the peremptory stage. This cannot be taken up. This is rejected. You want to take the suit in the different direction. That is the moral ground. And the last chance was given on the last day. If your lordship see the last portion, upon perusal, the amendment, the petition and schedule appears the plaintiff trying to incorporate new facts by changing direction of the suit property, which will change the nature and character of the suit property. According to the proviso appended to the provision and orders, no application for amendment shall be allowed after trial has commenced.
Show me the schedule, Mr. Mukherjee.
My lord. Kindly turn to the amendment application, page 20, my lord, the already of the plaint.
No, your amendment.
Amendment. My lord,
Schedule of amendment.
27 to 30. This is in Bengali. My lord.
উত্তর পূর্ব অংশের প্রায় কম বেশি এক কাঠা জমি
28,
এনক্রোচ করে
28
শাখায় ও
তিনতলা গৃহাদি নির্মাণ করেছেন এবং তিনতলা বিল্ডিং
তলা পাকা গৃহাদি নির্মাণ করিয়াছে
LICO
তিনতলা বিল্ডিং এর
yes
আইসি
LICO IIF গোল্ড ফিনান্স অফিসকে ভাড়া দিয়েছেন in my land they have encroached
উক্ত স্বয়ং
সুতরাং উক্ত তলা বিল্ডিং যদি বাদী নারী সম্পত্তির অংশ encroach করিয়া নির্মাণ করে তা সম্পূর্ণ বেআইনি ও অবৈধ হইতেছে উক্ত সম্পত্তির দক্ষিণ পশ্চিম দিকে অর্থাৎ নালিশি আরএস দাগে প্রায় কম বেশি 3 কাঠা 9 ছটাক দিস পার্টিকুলার্স হ্যাজ বিন ইন্ট্রোডিউসড 25 বর্গ ফুট জমি এনক্রোচ করিয়াছে
Was this already pleaded in the
Yes,
plaint?
yes,
Show me.
Well, kindly turn to the plaint,
Yes.
page 13, 12, 13, 10, 10, 12, 13. 10 is the,
Can you please read it out?
my lord, I am. বিভিন্ন সময় কত অপশন হচ্ছে 10, 12, 13, 23, 11 মানে পেজ 12 ফার্স্ট টাইম রিড।
Hmm.
3 নম্বর বিবাদী বাদী সম্পত্তির মধ্যে 3 নম্বর বিবাদী গিয়ে তাহাদের মিটার ফিক্স করিয়াছেন। দ্যাট ইজ অলসো দেয়ার।
Please speak into the mic.
ও আই এম সরি।
Because of the AC, the
My page 13, I am reading
Huh.
the last portion.
Huh.
1, 2 বিবাদী নম্বর কত তফসিলের 303 দাগে উত্তর দিকে কত তফসিল সম্পত্তি এনক্রোচ করিয়া গৃহাদি নির্মাণ করিয়াছেন এনক্রোচ কোর্শনে LIC অফিস ও II।
an arguable case has been made out by the petitioner. By the order impugned dated March 21, 2023, the learned civil judge, junior divisions, which court? Sirampur.
Sirampur,
Second court at Sirampur
junior division.
rejected an application for injunction on the
Amendment.
ground that, for
Amendment.
amendment of the plaint on the ground that the amendment was not only belated, but was also sought to, but if allowed, would also amount to changing the nature and character of the suit property. Prima facie, it appears that the pleadings with regard to encroachment had been specifically incorporated in the plaint. By way of the amendment,
Right.
the petitioner, the plaintiff sought to specify the measurements of the encroached portion.
My lord.
Next, the measurement, the nature of amendment would not change the amendment, if allowed, in my prima facie view, would not change the nature
Nature
and
and
character
character.
of the suit property. Suit. And it is not a case that the defendants cannot be compensated in some way or the other if such amendment is allowed at the belated stage. As the amendment, ঠিক আছে, ওটা পরের দিন যখন service upon the opposite parties, affidavit of service on the next date, let this matter appear on এই 26 তারিখ কিছু আছে? Can you serve and come back?
I'll try, my lord.
Parties and their learned advocate, তাহলে অন্য দিন দিয়ে দাও।
In the court below.
হ্যাঁ। ছাব্বিশ জুলাই রোড হয়ে যায় বৈদ্যবাটি।
Sirampur.
We have all for the proceedings, entitled suit number দুটো
At 2.
তারিখ 2 PM.
And my lord, the next date is, I have been told, stay.
Stay of all for the proceedings entitled suit number till September 30.
I am good.
Yes, next.
I'm
Daku.
Your Honor, may I be permitted to mention just a
Item
File.
number, Daku.
Item number 66, I am praying for adjournment on the ground.
Dekhe jao.
my lord.
67, I have 40 petitioner.
Yes, move it.
Suit for
বলতে চাই কি ছেলেটা?
no caveat.
What do you want to say?
My lord, item number 62 just the pass so escalated.
You want to do it?
I'm requesting for a pass over my
Then
seniors.
why are you mentioning and disturbing the court? I have not done anything. Those who want to do, let them do their matters.
যারা আছে তাদেরটাই নিচ্ছে।
Sorry.
Yes.
Miller, suit for declaration and consequential relief. I am the plaintiff, my lord. Defendant opposite party.
Why are you aggrieved?
Aggrieved, my lord, the suit where the learned judge by the order impugned or rejected my application under section 151, recalling the order of abatement. My lord, the face on the record, there is a my opposite party defendant died on 1996. Already defendant heirs
or substituted in place of deceased defendant, original.
What happened?
My lord,
Why was the abatement recorded?
in the order, sir, my lord.
You are saying substitution was effected. Still there was abatement.
No, still there, that's why I am
What
recalling.
recorded the abatement?
Yes, my lord.
Why?
My lord,
Where is that order?
no, I am not challenging the amendment, substitution, my lord. I am the defendant, defendant's died, and present defendants already substituted his son.
That is why I'm asking you, what was the reason why the court recorded abatement?
Well, the court recorded wrong, state erroneous statement. Because already order is passed, substitution order is there. And my plaintiff.
Order recording abatement is, দেখি একটু CPC টা দাও তো।
This is erroneous order on the face of the record, my lord.
Let me
It is
see one
completely wrong, my lord. That's why I am filed application 151 recalling the order itself. It is wrong on the face of the record, which I am SHAMPA manifest error. Justice. So that's why I am praying for 151 application. My application also rejected.
1 minute, please wait.
My lord.
Order refusing to set aside an abatement is an appealable order.
My lord, appeal. That's why I am praying file application 151 recalling. Why, my lord, I am praying for 151. My lord, this
Recalling of which order? Show me that order first.
my lord, kindly see order 198, recalling of the order, the original order.
Page?
Impugned order, my page. From last page number 4, from last page. This is appellable order, admittedly. But my lord, there is a provision, my lord, where the learned judge error in manifesting the error on face of the record, which the litigant suffer.
The
unnecessary.
Dependent on the both expired long ago, but no substitution taken by the opinion since deceased, the legal heirs do not take any steps for substitution.
Yes. Also substituted, my lord. Order is there.
Proceed, it is admitted.
And plaintiff also filed substitution application. There has been pending. Plaintiff's application substitution pending.
Admitted by operation of law.
Law.
Support. So now what is your application?
My application, my kindly see page number. Page number, my lord, 43. 151 application. 43, my lord. I am reading, my lord. Dorkhasto Shimota Karan Portal.
File an application for setting aside abatement. What is the problem?
My lord, problem, my lord, there is appeal, my lord, appeal itself, my lord.
Why appeal? Application for setting aside court recorded abatement.
Yes.
So why you can't file an application for setting aside abatement?
I am recalling the order 151 application also made before the learned judge. That
Why
is
151 when there is a application? All right, you show me that it is on record.
My lord, kindly see page number. Order this record.
There's no scope for any interim order. Both parties are dead.
Both parties dead, but my substitute, I am the plaintiff. My predecessor died in 2013. I filed the application. That application has been pending, still pending. I am showing before your lordship from the order sheet.
Why?
And
You may be all right, it will revive against the plaintiff.
And
with, you have not substitute defendants, what will you do?
And a defendant also died, original defendant, in place of original defendant, present defendant also substituted. Also substituted, my lord. Both the findings of the court, learned lower court below, my lord, is erroneous, wrong. Kindly see, my lord, that's why I am
Where
paying.
is your application?
My lord, the application.
Who will you serve?
Yes, application 151. My lord,
Alright, service upon the opposite parties. As also the learned advocate appearing on behalf of the opposite parties, let the matter appear on. Kata date thou. There is no scope for any interim
my lord,
order.
only the impugn order, my lord. Only limited scope.
লাভটা কি?
My lord,
They impose
maybe, my lord, there is some litigation be arising, my lord, kindly limited scope, till my lord, return.
Makes no sense. Suit has abated for like dismissal suit. I will stay that.
Milord, my lord,
No,
maybe limited scope, my lord, maybe
and you are asking for
limited.
something which is not permissible in law.
I am showing at the time of hearing, I am showing before, let's say, or several or in this court as well as the High Court, my lord, there is a order error in apparent on face of
I'm
the
not
report.
saying that. I'm saying when the suits have abated,
Yes.
where is the scope for any interim order?
No, only the impugn order question, my lord. I am not praying for suit.
তুমি বলো কবে খালি আছে? অগস্ট? দুটো তিনটে নাগাদ? তিনটে? 3rd August? 3rd August 2 p.m.
3rd August, grateful, my lord. In the meantime, my lord, impugn order only.
No, makes no, then your suit will revive. If I stay and order recording abatement, the suit revives. How can I do that? Chalo.
Milord.
Serve and come back. Upon the opposite parties, as also the learned advocates appearing on behalf of the opposite party in the court below. Parties in the court below.
Opposite parties as well as the learned lawyer.
Advocate, yes, yes.
Grateful.
They are not agreed or they are sued. How does it matter? Abated to abated. Your suit has gone, so they are not coming.
61.
The fact that they were filed and was with record, was it ever recorded in the order sheet?
Yes, my lord. I am annexed the order sheet.
All right.
I am annexed.
Chalo.
Grateful.
চারটেটা ডাকো।
এই যে আছে ওটা দিয়ে দিন executive service executive service oh it's the other side my lord it's that case wherein the suit has been dismissed and has not been restored as yet but injunction has been granted.
Yes, Mr. Ghosh.
Lord, kindly see Lord section 141 of the Civil Procedure Code. Especially it has been indicated
No,
in
that does
order
not.
9.
There is no manner of application here. Since no, it is an order passed under order 39 rule and 1 and 2, which has been restored.
Paragraph, what, which section?
Section 141 miscellaneous proceeding. The procedure provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. Explanation. In this section,
application.
the expression proceeding includes proceeding under order 9. Lord, order 9, rule 9 has been filed during operation of COVID. The suit was dismissed for default. Application under order 9, rule 9 was filed. The injunction was made absolute and it was affirmed up to this honorable court. Accordingly, upon dismissal of the suit, injunction was came to an end. Therefore, made an application under order 9, rule 9 and with an application under order 39, rule 1 and 2. Lord, court has power to grant during pendency of the order 9, rule 9.
Under which provision of law? I don't know. Tell me.
Or order for 141, section 141, my lord, can I see?
141 says what? Procedure provided in this code?
This code. In regard to suits,
Huh.
Lord, in case of a suit, I can filing a suit, I can make an application for injunction. Order 39 rule 1 and 2. And Lord, suit shall be followed. And Lord,
In
explanation.
all proceedings in any court of civil jurisdiction. Yes. So how CPC's provision will apply in all proceedings?
Lord, all proceedings, it is a proceeding under order 9 rule 9.
No.
Lord, I made an application for restoration of the suit under order 9 rule 9, as the suit was dismissed for default during COVID. Lord, therefore, the application is pending, and in connection with the application, I made an application for passing the interim order. It can be done. It is the only procedure.
Order 9,
And
rule 9 has not been heard as yet. Suit has not been restored at all.
In case of filing a fresh suit also, even before the hearing of the suit itself, the injunction order is granted in case
Oh, no.
the court thinks that it is necessary.
No.
Lord, so many years injunction is pending. Lord,
No suit
immediately
is
after that
pending at
order,
now, my
Lord,
lord.
kindly see what they have done.
Misapplication of
What
section
they have
141.
done. Lord, they have started construction, and this is the
Whatever may be, suit to be restored
No.
first.
it is not-
Suit to be restored first.
it has been registered as a separate miss case. And Lord, kindly see they are
Miss case may
continuing
be,
building construction on the land.
but there is no
Advantage
suit.
of this. That's why, Lord, initially court granted an order on their application. As you recall, when the provision of order 141 was shown, he has not restored the order of injunction. Against that, Lord, that apart, they have preferred an appeal. Appeal is only
Whatever may be at
appeal.
present,
No order was passed regarding stay. Then, Lord, suppressing the said fact come up before your lordship.
suit,
Kindly see, this is the
at
miscellaneous
present, suit is not living. Suit has not been restored as yet.
miscellaneous appeal against the same order. It is pending there. No injunction order was, no stay order was granted. So self order, kindly see.
But they have not restored the suit as yet. Suit is still
Uh,
lying as
Yes,
dismissed.
but that is an appealable order, even if it
Yes.
is a wrong order. You have preferred an appeal.
My
let
lord,
that be decided.
my lord, only the reason is
kindly
that,
see the order.
my lord, superintending power of my lord is enough.
This is not order
A
dated.
whimsical order has been passed when there is no suit. He has passed an order for restoration of injunction order. Only see the, my lord, trial courts.
Mr. Ghosh, 141 says what?
That's
That
Lord, this
in
proceed.
miscellaneous proceedings, including proceedings under order 9,
order 9.
You know, Lord, all miscellaneous proceedings.
CPC will apply.
CPC as
Does it mean that
as
if there is-
applicable to original suits. As
Yes,
applicable
that
to,
is the procedure,
yes, that is
but not substantive reliefs.
Lord, injunction is also a procedure to maintain the property during pendency
It
of
is a
the suit.
procedure for
Suit
granting
is not
injunction, but
living.
it is a substantial relief
And
granted.
Lord, that is not fact that it is a procedure. Injunction is procedure to maintain the suit property in its condition as it was.
No,
during the
then in
pendency
High
of the
Court,
suit.
all appeals are dismissed and we will pass interim orders.
Strange thing.
And Lord, that apart, your lordship kindly see
Ah.
this revisional application against order dated 27th February 23 and miscellaneous appeal kindly see. That is
The
pending.
general power of superintendence is not taken away.
No, I am not saying so. But Lord, they have suppressed it. They have got no relief there. And against the order of injunction,
These are
only
not
appeal
factored
lies.
now here.
Appeal lies, my lord, order 30, order 43, rule 1R.
Let
Kindly
the
see.
suit be restored first, then they can pray for any order. Suit is still dead. Even the court has passed contradictory order. My lord, only kindly come to order dated 21st February
Well, how this revisional application is maintained.
2023.
Proper.
Where is the order impugned? Show me.
Order impugned is last phase. Only its prior order is to be looked into, my lord, which will make everything clear.
It is an extension.
Just one page before.
Extension of the order already passed.
Yes.
My lord, kindly then only one page before, order dated 21st February 2023, this order also of the trial court. Kindly see.
trial court has observed that they have misleaded the court and obtained an order of injunction when the suit is not in existence.
But thereafter application was filed, that order has been recalled. And the injunction order has
That
been passed.
recalling order is absolutely wrong.
That's why I
How,
preferred an
when
appeal.
there is no suit, you can pass an order for it?
I am not.
This order,
Lord, since 2010, the injunction order is being maintained. It has been
There is no
upheld by
suit.
this honorable court. Also in revision, appeal. Lord has confirmed the order passed by the learned trial court. Lord, revisional court affirmed this, and thereafter, Lord, in view of this during COVID period, it was dismissed for default.
So you
Application,
got it restored. Instead of
Lord,
restoring the suit.
Lord, even your
you
lordship,
issue an order.
my lord knows the with application under section 5, a second appeal is filed. If the court thinks that there is urgency, court can even before disposal of the section 5 application grant an order of injunction. The Justice Jyotirmoyinath's judgment is reported that is still subsisting. It is in the field. Therefore, Lord, order 9, rule 9.
So then in that case, you would have had to make out exceptional cases. The court's order
Lord, it
doesn't
is an
record that.
exceptional case, Lord, the order has
No.
definitely.
But never said that in a non-existing takedown. Your misappeal, I am rejecting. I am directing the, setting aside this order, directing first to hear out the application for restoration. Take down.
Yes, yes,
Lord, your lordship, miscellaneous appeal have been preferred by them.
I will reject it.
And
Say
Lord, let
dispose
the
it
Lord status quo be maintained.
How?
Otherwise, Lord, they kindly see, Lord, what they are doing.
When
Huge
there is
construction they have started.
no suit, how does
Lord,
order
kindly
of
see,
can be passed?
taking advantage of vacating the interim order.
Take down.
Your lordship,
The
kindly.
divisional application has been filed challenging an order dated February 27, 2023, passed by the learned civil judge, Junior Division, 3rd Court, Paschim Mednipur, in J. Miss case number 52 of 2022. J. Miss case number 52 of 2022 is an application under Order 9, Rule 9 of the Code of Civil Procedure for restoration of title suit number 05 of 2010, which was dismissed for default on
Dismissed for default. Just a second. Lord, I am giving the date.
না এটা ফাইল করছে রেস্টোরেশন ডিফল্ট আরো আগে
when was it dismissed for default?
22nd.
না না না
এটা কত 795 তো
Note this, Lord.
9 for default. এটা short list.
It was dismissed for default.
Lord, I am telling you.
this is long back আরো আগে
আগে হয়েছে এটা ডিসমিস স্টেটেড
It appears that by an order dated February 21, 2023, the order of injunction, which was passed on, now which suit was dismissed on January 27, 2022,
ঠিক আছে জানুয়ারি
Yes.
which was dismissed on বললাম না? On January 27, 2022.
হ্যাঁ জানি তো মোর দেন 2 মাস কোভিড পিরিয়ডের পরেও 2 মাস বসেছি
ঠিক আছে ওটা দরকার নাই ডিসমিস আছে
On February 9, 2023, the learned advocate for the petitioners the opposite party, filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, which was allowed after ex parte hearing. By the said order, both parties were directed to maintain status quo with regard to the A schedule property till March 13, 2023. The learned civil judge, Junior Division, 3rd Court at Paschim Mednipur,
Order 9.
came to the finding that the ad interim order of injunction had been obtained by ad interim order of injunction had been obtained in the suit, had been obtained when the suit was already dismissed and no restoration had been filed.
রেস্টোরেশন ফাইল হয়েছে
The interim order granted on February 9, 2023 was vacated, and the order of injunction was rejected upon payment of cost of rupees 500, upon imposition of cost of rupees 500.
Cost is 500.
Thereafter, the plaintiffs filed an application under Order 9, Rule 9 of the Code of Civil Procedure.
No.
Yes.
In connection with order 9 rule
On
9.
March 19, come to the order dated February 21, Mr. Ghosh.
Not there.
It is there in the petition.
Well, yesterday only the petition, को first
Last
option
आगे
given.
last
हम
Yes.
change to देखते दिन.
last आगे पेज
Lord, this is 22nd, 21st January, 25th February. But it appears from the record that the land advocate for the petitioner has misguided the court such and such.
So before that you read, upon
On
perusal of the
record,
it appears that
appears
instant
that instant
case.
case has been filed on 9/5/22. 19/5/22 under order 9 rule 9. Yes. Paying for setting aside the dismissal order dated 27th January 22 to entitle to such a child.
But on February 9, 2023.
And we have this order is
Yes.
25.
Thereafter,
Yes.
an application under Order 9, Rule 9 of the Code of Civil Procedure was filed, bolam to. Tapore, which was registered as Jamie's case number 52 of 2022, praying for restoration of the suit. Another application under section 151 of the Code of Civil Procedure was filed for restoration of the interim order of injunction, passed on February 9, 2023.
That is with the cost. That order was sought to be recalled. Yes.
The learned court allowed the applications by restoring the interim order of injunction. Next paragraph. Aggrieved, the defendants have appeared before the court, approached this court with the submission that when the suit itself was non-existent, so defendant number 2 has approached this court, was honest in the eye of law and had not been restored. The question of re-imposition of the interim order passed on February 9, 2023 did not arise. Mr. Ghosh, learned advocate appearing on behalf of the plaintiffs / opposite parties, submits that the provisions of section 151 of the Code of Civil Procedure, read with section 151 of the 141, read with 151 of the Code, read with section 151 of the Code of Civil Procedure, entitles the learned court below to impose, to pass any ad interim order in order to protect the property in view of the emergency situation. It is further submitted that a misappeal was also preferred by the petitioner, which has been suppressed before the court.
Section 5 application also.
Mr. Ghosh contends that the order impugned is an appealable order. Next paragraph. Having heard the learned advocates for the respective parties, this court is of the view that section 141 would not help the petitioner in the opposite party in this case, as the provisions of section 141. Now, as the said section provides that the procedures available, the procedures prescribed in the code in respect of suits would also be applicable in proceedings, including proceedings under Order 9. In my view, this provision is with regard to the conduct of proceedings and not with regard to grant of substantive reliefs. When the suit itself does not exist. The proper procedure of the court ought to have been to allow the decide whether the suit would be restored or not. And if the learned court found material to restore the suit, the court should have then proceeded with hearing the application for injunction. Moreover, the order of ad interim injunction, which was extended by the order impugned dated February 27, 2023, was passed on February 9, 2023, also at a time when the suit had been dismissed. The suit was dismissed on January 27, 2023. 2022. After almost a year from dismissal of the suit, the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure was filed by the plaintiffs, and an ad interim injunction was allowed ex parte when there was no suit in the eye of law. The said order was once again extended, the said order was recalled upon, vacated by the court by order dated February 21, 2023, upon imposition of cost of rupees 500. Again, the said order was extended by invoking inherent power.
141 power.
No, powers under section 151 and 141 of the Code of Civil Procedure. By order dated February 27, 2023, when the suit was still not restored. This, in my opinion, the entire process, in my opinion, suffers from irregularity. The learned court did not have any jurisdiction to extend the ad interim order of injunction in view of the lack of jurisdiction, which goes to the very root of the order impugned, and in view of the fact that the order impugned suffers from contravention of law. This court invokes the general power of superintendence and admits and allows the revisional application, thereby setting aside the order dated February 27, 2023. The miss appeal number 37 of 2023, filed by the petitioner, is also disposed of accordingly. The order of extension of an ad interim order.
Dependent. Plaintiff filed miss appeal.
No. You filed.
appeal. Appeal, yes.
কি বললাম?
ঠিক আছে। আমরাই করেছিলাম। আমি জানি না
না কেটে দাও, হয়ে যাবে। The learned court below is directed to dispose of the application for restoration of the suit within the period of 1 month from date of communication of this order. Thereafter, the plaintiff shall be at liberty to file a fresh application under Order 39, Rule 1 and 2 of the Code of Civil Procedure for necessary orders.
Only one thing, Lord. Subject to your lordship, Lord. So far, your lordship's finding regarding 141, it is not procedure. Lord, maybe I may be given an opportunity to, Lord, show your lordship's judgment.
ওইটাকে বাদ দিয়ে দাও, ওটা 141 বলার দরকার নেই।
Lord, 141 power is there and court has exercised power under.
All right, I will record it. ওখানটাই বলে দাও যে although Mr. Ghosh, আমার ফাইন্ডিং গুলোতে, although Mr. Ghosh submits that the court has a power under exceptional circumstances to pass necessary orders under section 141 of the Code of Civil Procedure, this court is of the view that the order impugned does not reflect any existence of a situation would necessitate the court
No, that is not my submission.
to
Your lordship has
issue the
discussed-
order.
That is not my submission.
You are saying court can under
No,
exceptional
no, I'm not.
circumstances.
Lord, your lordship's finding is that
That's why I
this injunction application in connection with order 9 rule 9.
I am not taking that into
No,
consideration.
your lordship has held that it is
I-
not a it is not a procedure in a suit. It is procedure in a mis case. I am just on the point that is a procedure.
No, I am deleting
Court
that and
can-
incorporating what you are saying now.
No, I am not saying that. My question is not the 141 to be followed in case of a mis case also. So in suit.
Yes,
injunction
this
application-
case is followed. Yes, I have recorded that
No,
is
your
your
lordship
state.
has said that this is injunction application cannot be made.
I'm deleting that part. I'm not observing that.
Court can do it.
Yes, court can, but I do not think there is any reason for. আচ্ছা ওখানে লিখে দাও যে ওই পার্টটা delete করে দাও যে have in my view the application of section 141 in this case would not come to the aid of the plaintiff for the following reasons. A, the suit was dismissed on January 27, 2022. No application for restoration was filed. An application for injunction was filed on February 9, 2023. Praying for injunction in a dismissed suit. Therefore, the trial court came to a finding while vacating the order of ad interim injunction that the injunction was obtained by misleading the court and imposed cost of rupees 500. Again, an application under section 151 read with 141 of the Code of Civil Procedure was entertained without any reasons as to why the ad interim order, which was vacated on February by order dated February 21, 2023, should be extended. ঠিক আছে? The court has not disclosed any reasons as to what exigencies occurred for the court to have adopted such procedure to extend an ad interim order in a suit which is non-existent since January 27, 2022.
Not in a suit, but mis case. Mis case it was done in mis case. Mis case is a suit according to the procedure. It was not in the suit.
ছুটেই তো মিস
In a suit which was dismissed for default and the miscase praying for this restoration of the suit had not been allowed.
Yes.
Item 66, my lord, section 24,
Give it to me. 66 to the
68.
68.
Next. 68.
4:15.
No.
এখন কি করবো আমি? তুমি যেটা 68 টা দাও না। It will be in the list, sir. Just who is for your other side?
Mr. Shonok Bhattacharya.
What is this matter?
My lord, it was heard by your lordship on the last occasion. My lord directed me to produce some documents which I relied upon in the court below.
What is the matter?
Matter was there was a direction to restore possession on the allegation of the plaintiff that he was dispossessed during subsistence of injunction order. I came up before this court. This court remanded back the matter, directed the learned court to cause an inquiry. There was no inquiry and the order was directed in toto. Same order.
Oh, that one. ঠিক আছে, next day. এখন তো 6:30 4:30 বাজে। Yes, Mr. Mitro, you move your
My
mouth.
lord, this is by the application by the wife petitioner. My lord, for transfer of a matrimonial suit, my lord, from Sirampur to Howrah.
Howrah? I will reject this.
My lord,
This has
the
deserves
DB
rejection.
Act pending
Nah,
minor child, my lord.
You please withdraw or I will dismiss it.
My lord, kindly consider this aspect. My lord, minor
1 ঘন্টাও লাগে না।
lage na, but
না, take down.
some difficulty, my lord,
No.
kind. My lord, let it serve, my lord.
No, not at all.
My lord, this is only prayer, my lord. I am making, my lord.
I am easy with this, but this is extremely
My lord, the difficulty is, my lord,
indulgent.
here also, my lord, my lord, a DB Act proceedings is
Maybe
pending.
take down.
The husband is appearing, my lord. Kindly
The
consider.
court does not find any reason to entertain this
The wife
application
has
for
opted
transfer
in
of matrimonial
for
suit number 1 of 2023 to the court of the learned additional district judge, second court at Sirampur, Hooghly. Now, from the court of the learned additional district judge, second court, Srirampur, Hooghly. Now from the court of the learned additional district judge, second court, Srirampur, Hooghly, to the court of the learned district judge at Howrah. The distance between Srirampur and Howrah is around koto kilometer? 40 kilometers. And the
Wife is also suffering from it.
and there are several modes of communication which are comparatively easy and convenient.
Child minor
The only fact that the petitioner lives with her 9-year-old child cannot be a reason for transferring the suit. The court does not find any reason to pass any order as even taking as order stop. The petitioner has failed to produce any proper hardship. No, has not been able to impress the court with regard to any cogent ground for seeking such transfer. The petitioner will not suffer any hardship if she is required to contest the matrimonial suit in Howrah. Dismissed. Yes, Cholo.
Will it be in my lord's kind consider, my lord, if the matter is taken up on Friday? My lord,
No,
if
I have.
my lord, I'm good.
You please follow the list. It will
My lord,
be
I'm
taken
good.
up. ওটাকে motion, urgent motion এ দিয়ে দাও কিছু একটা করো।